Good afternoon, and thank you all very much for joining us here after a delicious lunch. I'd also like to thank the conference organizers for deciding to have a panel on plea bargaining. We're very excited to speak with you. I'll be introducing each of our speakers before they give their presentations, and then after the presentations are done, I'll assist with the question and answer session. Our first speaker this afternoon is Professor William Ortman, who was until last month a professor of law and the David Adamany Research Scholar at Wayne University in Detroit, Michigan. He will join the faculty at the University of Georgia in the fall. Professor Ortman has written extensively about the history of plea bargaining, how plea bargaining has affected legal doctrine, and how plea bargaining could be reformed. Professor Ortman holds a bachelor's degree from Swarthmore College and a law degree from the University of Chicago. Prior to joining the faculty at Wayne State in 2016, he clerked for Judge David Tatel of the DC Circuit, worked as both a criminal defense lawyer and a civil litigator, and served as a Klemenko Fellow at Harvard Law School. Professor Ortman.
Thank you very much, Carissa, for the introduction, and thank you all for being here. My topic is the history of plea bargaining in America. I'm going to start by telling you about two American criminal cases separated in time by 2 centuries. They are ordinary cases, by which I mean that they were of the utmost importance to the people involved and to their loved ones, but probably not to anyone else. They offer snapshots of normal American criminal justice at 2 moments in its history. We begin in New York City in 1823. John Sheehan, an orange vendor, has been indicted for stealing 6 hats from a local store. The case goes to trial, where the district attorney's witnesses testify that 3 of the stolen hats were found in a cellar that belonged to Mr. Sheehan. When it is Mr. Sheehan's turn, his witnesses vouch for his good character, and his lawyers argue that the real thief was a man named Quigley, who they had subpoenaed, but who had secretly left the city to avoid testifying. When that's done, the judge explains that the prosecution's case is built on circumstantial evidence. And that is evidence, he says, that is particularly proper for the consideration of a jury. He then carefully reviews the facts. He lists 4 circumstances that suggest guilt and 5 pointing the other way. Among the latter, Sheehan had difficulty walking. And so the hat shop's proprietor likely would have noticed him if he had been in the store. The jury returns a verdict of not guilty. Now we will fast forward 184 years. So it's 2007. We are in Chicago, where Martez Wise is charged with 3 serious drug felonies. So he is facing up to 75 years in prison if he's convicted. So Mr. Wise meets with his lawyer, and he tells his lawyer that he was framed by the police officers. They'd approached him in a park. They demanded information about drug dealers in the area. And when Mr. Wise told them that he didn't have any information, they arrested him, and they falsely claimed that they had found drugs that belonged to him. Mr. Wise's lawyer listens to this, and then he advises his client to plead guilty. He explains that if Wise goes to trial, he will risk far more prison time. Wise does not wish to plead guilty. He had been framed, but he takes his lawyer's advice. And so he and his lawyer appear before a judge named Ricky Jones. There is a settlement conference where the judge offers Mr. Wise a 1-year sentence if he pleads guilty, and Wise accepts the offer. Back in open court, Judge Jones delivers the standard colloquy, confirms that Mr. Wise had signed the proper forms, and accepts his plea. At the end of the hearing, Wise thanks the judge for being honest and reasonable. Judge Jones thanks him in return and then imposes the agreed upon sentence. Usually, that would be the end of the story. There's a coda here because more than a decade later, after Mr. Wise had served his sentence and after two of the police officers involved in his arrest had gone to prison, Chicago judges vacated his conviction and more than 200 like it. So today I will try to tell the story of how American criminal justice transformed from a system of trials to a system of pleas, from John Sheehan's trial to Martez Wise's plea hearing. And that's a story that has 3 chapters. So chapter 1 will explore plea bargaining's origins, which were in the 19th century. And fair warning, the beginnings are somewhat murky. Chapter 2 describes plea bargaining's normalization. And that's a process that begins in the 1920s and is complete by about 1970. So chapter 3 concludes by looking at an unsuccessful but a pretty widespread movement to abolish plea bargaining in the 1970s. Criminal justice in America is intensely local. And so what passes as standard practice in one county courthouse can be unfamiliar to practitioners just a county away. And so that means that seeking plea bargaining's origins means looking for how it emerged in a specific jurisdiction. And so we will primarily do that. I will primarily do that in Middlesex County, Massachusetts. That is just outside Boston. And the reason is George Fisher's essential book, Plea Bargaining's Triumph, which I will be drawing on in this part of the talk. So plea bargaining first appeared in Middlesex County in cases brought under the state's liquor law. And that was a criminal law that prohibited selling liquor without the proper license. So the earliest example that Fisher found was the 1807 case of a man named Josiah Stevens. The district attorney had brought a 4-count indictment against Stevens under the liquor law. Rather than go to trial, the DA and Stevens appear to have made a deal where Stevens accepted a conviction on count 2, and in return, the DA dropped the remaining charges. And so what we would today call charge bargaining had arrived in Massachusetts. So you might wonder why liquor law, what made this law special? And there were 2 things. So first, each conviction carried a fixed, rigid sentence. And so judges had no discretion to tailor punishment to the crime. Second, the law gave prosecutors authority to dismiss counts in an indictment without a judge's approval. When you put those 2 things together, what you get is prosecutorial leverage. So DAs threaten defendants with multiple counts, and so lots and lots of punishment, unless they pled guilty, and there was nothing that judges could do about it, even if they didn't like what was happening. So Middlesex County DAs charge bargain liquor law indictments, not in every case, but with increasing frequency until 1852, when something interesting happened, which is that the legislature ended the practice. So it changed the liquor law to require that judges approve dismissals of pending charges. And the charge bargaining system disappeared immediately. And so the very next year, out of 24 liquor law cases in Middlesex County, 21 went to trial, and none of the others involved charge bargaining. And so what that meant for the Middlesex County DAs was, well, if they still wanted to avoid trials, they needed other strategies. And so they found one in the mechanism of placing cases on file. So they had the power to postpone the sentencing for a defendant who had been convicted. And so that was a practice called, or known as, putting the case on file. And it was another source of leverage. So in exchange for a defendant's agreement to plead guilty, prosecutors could, in exchange, agree to indefinitely postpone sentencing. And then if the defendant stayed off the radar, the pause could become permanent, and otherwise, the original sentence could be imposed immediately. And if that sounds a little bit like probation, it should, because probation grows out of this practice. All right, so to this point, I've been talking about prosecutorial strategies for avoiding trial. Prosecutors had leverage to plea bargain liquor law cases up until 1852. They had leverage to bargain cases where they could put the case on file. They also had leverage in homicide cases because they could accept guilty pleas to manslaughter where they had charged murder. And so initially, plea bargaining in this jurisdiction is pretty much limited to those scenarios. But then, in the last quarter of the 19th century, guilty plea rates begin rising, and they begin rising quickly. And so by the turn of the 20th century, 87% of adjudicated cases have been resolved by plea instead of trial. And so the question is, well, what's the mechanism? What mechanism explains that shift? And the key actor turns out to be judges. So in the last quarter of the 19th century, as Fisher puts it, Middlesex County judges became full partners with prosecutors in a, quote, thriving practice of sentence bargaining. And so that means that judges rewarded defendants for pleading guilty by imposing punishments that were less severe than if they had gone to trial. And so the numbers tell the story. This is Fisher's breakdown of a sample of breaking and entering cases between 1880 and 1900. And although the average value of stolen goods was about the same in cases that went to trial and cases that were resolved by plea, there's only a $3 difference, the average sentence for plea cases was half the average sentence for trial sentences, for trial cases. And that is very strong evidence of sentence bargaining. So studies of other American jurisdictions confirm that the second half of the 19th century saw guilty pleas grow from a nascent practice into a pervasive one. So in their history of plea bargaining in New York City, which is also a central reading on this topic, Mike McConville and Chester Mirsky found that an institutionalized guilty plea system rose up there between 1850 and 1865. And in Alameda County, California, Lawrence Friedman and Robert Percival discovered guilty plea rates rising from 22% during the period 1880 to 1890 to 36% 2 decades later, so smaller numbers than Middlesex County, but still quite striking. The question remains, in Middlesex County and elsewhere, why did 19th century prosecutors and then judges turn to plea bargaining? So theories abound. There are lots of explanations. I will just mention a few of the most prominent. So one theory is that plea bargaining emerged in response to rising numbers of criminal cases. So this is the caseload hypothesis. And the logic is straightforward. It's that plea bargaining enables prosecutors and judges to dispose of more cases. And so when caseloads rise, they turn to it. On the other hand, studies indicate that high criminal caseloads are neither a necessary nor a sufficient condition for high guilty plea rates. And so the caseload hypothesis remains contested. Another theory connects plea bargaining's ascendance to the complexity of trials. Right, so trials were abundant before plea bargaining, but they didn't look a whole lot like modern American trials. Right, so they were very fast. They often lacked procedures that today we think are essential. And so that begins to change in the late 19th century, right? So just as plea bargaining is entering this period of dramatic growth. And so proponents of the trial complexity hypothesis argue that that's not a coincidence. So that thesis is also contested. Fisher found little evidence for it in Middlesex County, and neither did Mirsky and McConville in New York City. So the explanation for plea bargaining's rise in Middlesex County that I find most compelling is somewhat simpler than the trial complexity or criminal case load pressure hypotheses, and it's about power. So as Fisher wrote, prosecutors and judges in the 19th century turned to plea bargaining because they could, right? It's not hard to see why prosecutors and judges have the motive to plea bargain, right? It made their jobs easier. It left them more time to work on other cases or to work on or to pursue other endeavors. But maybe more importantly, it assured them of victory. Right? DAs, district attorneys, got convictions. Judges avoided appellate scrutiny. And so they had the motive to plea bargain. And when motive combined with opportunity, as in the liquor law scenario, as in the on-file mechanism, plea bargaining followed. I want to be careful not to overgeneralize, but plea bargaining's rise in America elsewhere may have had different causal explanations. But this formula of motive and opportunity does a good job of describing what we've just talked about in Middlesex County. So plea bargaining enters the 20th century as a pervasive practice. But it was not yet the normal way of doing criminal justice in America. It remained in the shadows. Few outside of the world of lower criminal courts understood its scale or scope. And when the public or appellate courts caught a glimpse of it, they usually recoiled. So for plea bargaining truly to become the criminal justice system, and our Supreme Court has conceded that it is in the 21st century, American law and its legal profession would have to accept it as normal, but first they had to discover it. So enter the crime commissions of the 1920s. So elite lawyers at this time realized that they had very little idea about what actually happens in American criminal courts. And so they formed commissions at the city and the state levels to find out. And that started in Cleveland, Ohio. Ideologically, these commissions were capital P progressives, and that's in no small part because of the influence of Roscoe Pound, who co-led the Cleveland study. So what did these progressive crime commissions find? So most importantly, for my purposes, they find lots and lots of guilty pleas. So this is a chart that Raymond Moley, who is a central figure in the Crime Commission movement, put together at the end of the decade. And it shows guilty plea rates in more than 20 American cities. Only 3 cities had rates below 60%. So 10 were between 70 and 79%. 6 were between 80 and 89%, and 5 were already 90% or higher. And so at the moment of this discovery, guilty pleas had already become the main pathway to conviction. The commissions immediately rejected the naive explanation for high guilty plea rates, the idea that guilty pleas are a marker of a defendant's repentance or remorse. And they saw what was really happening, which was compromise. They were shocked to discover that compromises had overrun the American criminal justice system. And so for the most part, they condemned it. And they had 2 different reasons for condemning it. First, they thought that compromise manifested prosecutorial corruption or at least weakness. And second, they believed that compromise allowed defendants to escape without their due punishment, undermining the force of the criminal law. The objection to plea bargaining that leaves out, the objection that they missed, is more interesting, I think, than the ones that they raised. They were not worried about what most bothers today's critics, which is that plea bargaining is coercive. Right, so the precondition for coercive plea bargaining, which is substantial trial penalties, as my fellow panelists will talk about in more detail, those were already present. Beyond that, appellate courts had been warning that compromise verdicts could ensnare the innocent for a very long time. And yet, while the progressive crime commissions condemned plea bargaining on other grounds, coercion barely registered. So I will come back to that. For now, the essential point is that the plea bargaining entered the American legal profession's consciousness far from normal. That soon started to change. And the first steps were taken by academics, by legal realists. And legal realism is an intellectual movement that is known more for its innovation in legal theory than for any interest in criminal law. And yet when it comes to normalizing plea bargaining, they played an important role. So two leading realists, Charles Clark and Thurman Arnold, conducted a study of the federal district court in Connecticut. And broadly speaking, they found what the crime commissions had, right? They found that compromise was everywhere. But their reaction was very different. So where the progressives had seen calamity, they just saw efficiency. So they declared that, quote, the federal criminal courts present a smoothly working system. Thurman Arnold expanded on that, and he wrote that, quote, criminal cases should be frankly compromised in the discretion of the prosecution. But what about those progressive objections, right? That plea bargaining represents corruption by prosecutors and escape by defendants. Those were easily sidelined using realists' conceptual tools because they rested on latent formalisms, and realists made a point of dismantling formalist legal thinking. So the claim that compromise means corruption, that relies on a formalistic idea that statutes have to be enforced to the maximum without discretion. Realists had no time for that kind of idea because they were enamored with prosecutorial discretion. Progressives had also assumed that the law provides a single correct punishment such that anything less than that is escape. But realists denied that legal questions necessarily have determinable correct objective answers. So they could embrace the idea that either a lenient sentence following a plea or a harsh sentence following a trial could be legally valid. And with the progressive objections off the table, it was easy for realists to embrace plea bargaining on the pragmatic grounds that it resolves cases quickly and cheaply. But there is one important point where the realists and the progressives were on the same page because, like the progressives on the crime commissions, the realists didn't pause to consider plea bargaining's coerciveness either. So that difference notwithstanding, by the middle of the 20th century, two very different views of plea bargaining had emerged. So progressives thought that plea bargaining entailed corruption and escape. Realists rejected those objections and embraced plea bargaining. And the question is, all right, so which set of views prevailed? And the answer is that the realists won. And by the middle of the 20th century, the commentariat and then ultimately the US Supreme Court had embraced plea bargaining as the new normal. There were two major criminal justice surveys in the middle decades of the century, one by the American Bar Foundation and the other by a presidential commission. Both emphasized that plea bargains serve the private interests of prosecutors and defendants. But besides that, they argued, the system would break down without plea bargaining. So they adopted both of the realists' responses to the progressive objections. So they agreed with the realists' view of prosecutorial discretion, and they went further than the realists had in rejecting the idea that defendants escape their due punishment when they take favorable plea deals. So mid-century judges revived the idea that the progressives of the 20s had decried as naive, right? That a guilty plea is a marker of repentance and so makes a defendant deserving of less punishment. Some even took the position that going to trial is a punishable act. So a judge in Chicago told a defense lawyer during this period that if his client pled guilty, the sentence would be 2 to 5 years. If he went to trial and he lost, the sentence would be 25 years. The judge explained his thinking. He said, quote, "He takes some of my time, I take some of his. That's the way it works." Now, mid-century American lawyers did have some reservations about plea bargaining. So this is when concerns about plea bargaining coercing innocent defendants were first raised in a full-throated way. So in 1951, a young lawyer named Sam Dash, he would later become famous as the chief counsel to the Senate Watergate Committee, he spent 5 months watching court proceedings in Chicago. And so, summing up that experience, he wrote that the, quote, "methods used by the prosecutor and the judge to obtain a plea of guilty to a lesser charge from an unrepresented defendant often amount to coercion performed in open court." Charges that plea bargaining is coercive, right? Particularly where there are significant trial penalties. That had legal implications as well as moral and policy implications because the US Supreme Court has long held that guilty pleas must be voluntary. And so the question was, are pleas voluntary when they're induced by threatening a defendant with a much harsher sentence if he goes to trial? So that is going to be the last hill on plea bargaining's road to normalization in America. So defenders of plea bargaining and the US Supreme Court, they had to find a way to rationalize plea bargaining's voluntariness. And the principal strategy was to conjure a distinction between promises of leniency, which are permissible because they benefit a defendant, and threats of severity. So the difficulty with this strategy is what's often called the baseline problem, because without an account of a defendant's proper sentence, a benefit and a penalty are just the same thing seen from different angles. Right? You can only distinguish a penalty from a benefit once you start from a baseline, because then anything above the baseline is a penalty and anything below it is a benefit. So the question is, how did mid-century writers and ultimately the US Supreme Court deal with the baseline problem? And the answer is they didn't. So mostly they ignored it. But their conclusion that plea bargaining represents leniency assumes that the proper normative baseline for punishment is a post-trial sentence. Neither plea bargaining's defenders in the crime surveys nor the Supreme Court sought during this period to justify that assumption. But if trials had been the norm and plea bargains were the exception, well, then the assumption makes some sense. However, by 1970, when plea bargaining is fully normal, 90 to 95% of convictions were by plea. So mid-century writers and the Supreme Court they paper over plea bargaining's coerciveness, but why? I think the answer is that they thought that they had to. If plea bargaining was understood as embodying threats rather than benefits, then it would be unlawful, it would be unconstitutional, and the system would crumble, in their view. But the system must not crumble, and so the imperative to keep the system running meant clearing legal and moral obstacles in plea bargaining's path by whatever means necessary. And so the is of plea bargaining had justified the ought, and plea bargaining's normalization was complete. But our story has one more chapter, and that's because in the 1970s, there's a rearguard action in the form of movement to abolish plea bargaining. So the movement begins in earnest in 1972 with the National Advisory Commission on Criminal Justice Standards and Goals. So President Richard Nixon's Justice Department had established this commission to study potential criminal justice reforms. So the commission creates a task force on courts. It's composed of lawyers and academics. And so they report back the legal profession's standard line about plea bargaining at the time, which is, yeah, it's basically fine. It needs some reforms around the edges. The commission disagreed with its own task force, and it disagreed strongly. So it concluded that plea bargaining serves, quote, no legitimate function. And it wrote that when criminal outcomes are determined by horse trading, the result is, quote, reduced rationality in processing of criminal defendants. And so the commission demanded the complete abolition of plea bargaining within 5 years. The American legal profession, having fully normalized plea bargaining, answered immediately. So the commission presented its work, including the plea bargaining proposal, at a major conference in Washington in 1973. Speakers and attendees railed against it. So at a session on the first night of the conference, one of the organizers joked, quote, perhaps this meeting should more appropriately be called the Convention of the District of Columbia Chapter for the Preservation of Plea Bargaining in America. The most substantive criticism came from a panel the next day where a prosecutor, a defense lawyer, and a judge all spoke against it. So the prosecutor recognized that plea bargaining discourages defendants from asserting rights and saw that as a benefit rather than a cost of plea bargaining. The defense lawyer emphasized that plea deals are in the private interests of both prosecutors and defendants. The judge was the most scathing. So he declared that abolishing plea bargaining was, quote, an almost asinine idea because, quote, we have been happily plea bargaining ever since the founding of our country. That was not true. And we've seen today that that's not true. But by 1973, plea bargaining had become so normal that a practitioner could mistake it for natural. All three speakers were seemingly unable to fathom a different way of doing things. On the last day of this Washington conference, when attendees met in their state delegations, most states roundly rejected the commission's proposal. So, it's one thing for a national commission to propose abolishing plea bargaining. It's another thing to try it. But that is what a handful of prosecutors and judges in jurisdictions around America attempted in the 1970s. So it began with partial bans. In Oakland County, Michigan, for instance, a newly elected county attorney prohibited his prosecutors from plea bargaining in drug cases in 1973. Later that year, in Maricopa County, Arizona, the chief prosecutor banned plea bargaining in murder, manslaughter, and robbery cases. By 1975, a few officials were ready to take a more ambitious step and try to end plea bargaining altogether in their jurisdictions. And that included the Attorney General of Alaska. So he directed the prosecutors in his state to stop, quote, engaging in plea negotiations with defendants, full stop. He conceded in his memo to his workforce that this was going to mean more work for them, but he insisted that it was worth it. And he wrote, quote, if we can do this, the office will have accomplished something really meaningful. Could they do it? No, they could not. And so in the Michigan County, where the DA had barred plea bargaining in drug cases, prosecutors did mostly stop making deals with defendants. But that didn't end plea bargaining. Instead, the focus shifted to judges who cut their own deals. One judge explained to a researcher, when faced with an unpleasant policy, resourceful attorneys, assistant prosecutors, and judges will generally find acceptable ways around it. The Alaska experiment had the same fate. So the Attorney General's policy, it did effectively stop prosecutors from engaging in sentence bargaining. But a review of case data showed that they continued to allow defendants to plead to lesser offenses. And so charge bargaining continued unabated. And, like in Michigan, lots of the judges opposed the policy. And so, like their counterparts in Michigan, they just took up plea bargaining with defendants themselves. So one judge explained he would, quote, read the complaints looking at the seriousness of the charges and then try and bargain the weak cases. So eventually, the Alaska Supreme Court tells the trial judges, hey, you need to cut that out. But the judges found they could achieve the same result by making it known that they would sentence defendants who went to trial more harshly than defendants who pled guilty. And so as in Michigan, the Alaska plea bargaining ban had been sabotaged by other actors in the criminal justice system. Normalized plea bargaining was simply too strong. So the movement to abolish plea bargaining, it does not achieve its goals. So how then should we think about it? So I think that it is best understood as an unheeded fire alarm. The abolitionists tried to warn Americans that something basic had gone wrong in their criminal justice system. So what happens next? Well, in the 1980s, the American criminal justice system exploded into mass incarceration. Right? Plea bargaining didn't cause that, but it facilitated it by sidelining the procedures that would otherwise have made a rapid expansion of the carceral system impossible. And so if the American legal profession had answered the abolitionists' fire alarm, American criminal justice might have taken a very different path. So as I reach the end, I want to return to the cases of John Sheehan and Martez Wise. So if this talk has had a core thesis, it's that the American legal system never adequately confronted what it lost by moving from a system of trials to a system of pleas. Right? This has been a story of institutional momentum, not institutional design. American plea bargaining has had many practitioners, but few, if any, real architects. So what was lost? I would need another 30 minutes to try to really answer that question. So I will end by pointing to just one thing that was lost. At John Sheehan's admittedly imperfect trial, neutral decision makers, a judge and a jury, did their best to decide the case correctly, and they were aided in that by adversarial advocates on both sides. At Martez Wise's plea hearing, there were prescribed forms and there were standard scripts, but there were no neutral decision makers and there were no adversarial advocates. Americans hadn't just lost a process, they'd lost the effort to get it right. Thank you very much.
Wonderful. Thank you so much, Will. I'm going to pick up where Will left off, talking about what it is that we have in an adversarial justice system. So one of the defining features of a common law country is the adversarial system of justice. And an adversarial system of justice is one in which the two opposing parties present evidence and arguments to a judge or a jury who then decides which party will prevail in the case. And the fundamental assumption of the adversarial system is that this presentation of evidence and arguments is most likely to arrive at the truth. Now, as Will suggested, plea bargaining replaces the adversarial system of justice, and it replaces it with a negotiation between the parties, thus restricting or removing the judge and jury from the process. The system of plea bargaining is based on a number of assumptions, including that efficiency is an important goal of the justice system and that the parties will be able to effectively bargain and reach a fair outcome. Now, my goal today is to question some of those assumptions, but to do so specifically by talking about how plea bargaining developed in the United States as compared to other common law countries. And then I'll offer some thoughts about how to consider the phenomenon of plea bargaining in common law adversarial systems as compared to inquisitorial systems. So let me begin with a very brief discussion of the development of plea bargaining in the United States, including an introduction of the two major types of American plea bargaining, the sentence bargain and the charge bargain. Now, as Professor Ortman ably explained, plea bargaining initially developed in urban criminal courts. It didn't come to light until the early 20th century, and it wasn't embraced until later in that century. And I'll say, if you were interested in the information that Professor Ortman shared with you, I highly recommend his 2020 article, How Plea Bargaining Became Normal, that was published in the Boston University Law Review. I want to pick up talking a bit about the U.S. Supreme Court cases that put their seal of approval on plea bargaining. The first of these cases I want to mention is called Santabello versus New York, a 1971 case. In that case, a prosecutor had failed to abide by a promise made during plea negotiation, specifically a promise not to make any recommendation at sentencing. Not only did the prosecutor go ahead and make a recommendation, but he recommended the maximum sentence. The case made its way up to the U.S. Supreme Court, who said that such plea agreements are enforceable, and a defendant could withdraw the guilty plea if the government failed to live up to their side of the bargain. Now, this type of agreement, the agreement at issue in Santabello, is one common form of plea bargaining, an agreement about sentencing, sometimes referred to as a sentence bargain. A sentence bargain can include a promise by a prosecutor not to recommend a sentence, which was the case in Santabello, or a promise to recommend a particular sentence, as you might imagine, a lenient one, and these promises are made in return for the defendant pleading guilty. Now, as I said, a sentence bargain is not the only type of common American plea bargaining. There's another type of bargain called a charge bargain, which was the subject of a 1978 decision by the U.S. Supreme Court, Byrne versus Hayes. And in that case, the court rejected a constitutional challenge to a charge bargain. Now, a charge bargain is an agreement in which a defendant agrees to plead guilty in return for one of three things: either a dismissal of some charges from a multi-charge case, allowing the defendant to plead guilty to a lesser charge, or promising not to bring additional charges. Byrne involved that third type of charge bargain. The prosecutor in that case threatened to bring more serious charges if the defendant wouldn't plead guilty to a charge of forgery and agree to a 5-year sentence. The defendant refused, and the prosecutor responded by bringing the more serious charge, which carried a sentence of life in prison. And Byrne, who had indeed committed forgery, was then convicted of this more serious charge and sentenced to life in prison. The U.S. Supreme Court upheld that sentence and the conviction on appeal. The justices said that the prosecutor's attempt to obtain a guilty plea by threatening the more serious charges didn't violate our country's constitution, as long as the defendant had the opportunity to bargain with the prosecutor, and as long as the defendant was free to reject the prosecution's offer, then the charge bargain was constitutional, according to the Supreme Court. So in the wake of Santabello and Byrne and other developments, plea bargaining in the United States became even more popular. Only 3% of convictions right now in the United States are the result of a criminal trial. The rest are the result of a guilty plea. We suspect that many, if not most, or close to all of those guilty pleas are the result of a plea bargain, but that data isn't collected systematically, so we don't know for sure. But turning from the United States to some other countries, the US is not the only common law country where plea bargaining takes place. There are other common law countries, including Australia, England and Wales, New Zealand and Scotland, all of which allow plea bargaining, though the practice looks a bit different depending on the country that you look at. So I'm going to spend a lot of time talking about what plea bargaining looks like in those countries, but before I do that, I have a few caveats. First of all, I want to just note that I'm referring to Scotland as a country, even though it's obviously part of the United Kingdom. And in calling Scotland a country, I don't mean to be calling for Scottish independence or endorsing political parties that do that. I'm not trying to make a political claim at all. Instead, I'm really just using the term for two reasons. First, because I feel like jurisdiction, which is probably the better word to use, sounds very clunky. It doesn't have the same alliteration, common law, countries, But that aside, I also think it's descriptively accurate when talking about the criminal justice system to refer to Scotland as a country because it effectively operates as an independent country in important ways when it comes to law. And for those of you who love history out there, I'll just note that although the 1707 Treaty of Union disbanded Scottish Parliament, replacing it with a United Kingdom Parliament that included Scottish representation, the treaty included a specific condition that the Scottish legal system remain a separate entity. And as a consequence, when it comes to criminal law cases, Scotland effectively functions as an independent country. I have one more caveat about Scotland. I don't know if there are any Scottish people here today, but just in case, I want to be very precise. Some people might object to the characterization of Scotland as a common law country on the basis that Scotland has at times been characterized as having a hybrid system, that is a system that incorporates both aspects of the common law and the civil law, but when it comes to criminal law, Scotland resembles other common law countries in all important respects, including that it's an adversarial system. Okay, so caveats about Scotland to one side. I have one additional caveat. One more note. I'm going to be describing how plea bargaining operates in other common law countries, but there is an important lack of transparency surrounding plea bargaining, especially in countries outside of the United States. So plea bargaining, by its nature, is an out-of-court negotiation between prosecutors and defense attorneys. And because that negotiation occurs outside of court, it's not public. It can therefore be difficult to accurately describe what happens in plea bargaining. Now, I should add, that's not to say that the terms of plea bargains never become public. In some cases, the terms of a plea agreement will end up being discussed in a court opinion, and in some countries, the relevant procedures for plea bargaining are formalized in rules of criminal procedure. But often, plea agreements are informal, they're not recognized in open court, and the practice isn't subject to formal legal regulation. And so in those countries, it's sort of difficult to know precisely how and when plea bargaining occurs. It affects, right, this lack of transparency affects our ability to compare how plea bargaining happens across countries. And because of this lack of transparency, in my description of what happens in other common law countries, I have to rely on secondary sources as evidence about how plea bargaining occurs. Among other sources, my remarks today draw heavily from a 2016 article in the William and Mary Law Review by Professor Paul Marcus and others, which collected responses from judges and lawyers in a number of different countries about various questions related to plea bargaining. So if you'd like to know more, I recommend that article to you as well. Okay. With all of those caveats out of the way, let me discuss how these 4 additional common law countries approach plea bargaining and compare those approaches to the United States. Okay, I'm going to begin with charge bargaining. As I mentioned earlier, a charge bargain is a negotiation in which a defendant agrees to plead guilty in return for the prosecutor either dismissing some charges, allowing a guilty plea to lesser charges, or a promise not to bring additional charges. Here's how charge bargaining plays out across these countries. So charge bargaining is an accepted but informal practice in Australia, England and Wales, and Scotland. That is to say, while charge bargaining happens, it's not necessarily recognized in open court, nor is it regulated through rules of procedure. While the legal and formal status of charge bargaining is quite similar in these three countries, the role of the judge in accepting or rejecting guilty pleas that result from a charge bargain differs. In Australia, the court, the judge, is largely bound to accept the guilty pleas that result from a charge bargain. They cannot reject them. In England and Wales, however, many judges believe that they have the power to refuse to accept a plea bargain, to refuse to accept a plea of guilty if it's not compatible with the facts as they understand them of the case. And Scotland falls somewhere in the middle. Scottish judges don't have an acknowledged power to refuse to accept a guilty plea, but the practice appears to be that judges, if they don't agree with a guilty plea in a particular situation, if they don't agree with the charge bargain, will ask the prosecutor to reconsider whether this plea ought to have been accepted in some circumstances. Okay. Now, charge bargaining in New Zealand is more complicated. Unlike Australia, England and Wales, and Scotland, where charge bargaining is acknowledged but informal, the acceptance of charge bargaining in New Zealand is more tenuous. The official stance is that the parties should not negotiate over criminal charges, and there are even written guidelines that prohibit prosecutors from initiating charge bargaining negotiations. Nonetheless, there's evidence from interviews and surveys that charge bargaining does occur at least sometimes, but because of its sort of uneasy legal status, when it does occur, it's done in secret and it's really not acknowledged. Now, charge bargaining is most formalized and accepted in the United States. Our court rules contemplate the practice. As I noted earlier when discussing the Bordenkircher case, the Supreme Court has rejected constitutional challenges to the practice, even under circumstances where the practice appears to be coercive. But I say it's incredibly formal, sort of more formal and accepted in the United States than in elsewhere, because in many American courts, including in our federal courts, there are written plea agreements which memorialize the term of the charge bargain, and those agreements are entered into the court record as an official document. And while judges in most U.S. states retain the power to reject charge bargains, some appellate courts have begun to push back against that practice, telling them that they must accept them. Okay, now let's look at sentence bargains. As I mentioned earlier, a sentence bargain is when the prosecutor agrees to make a favorable sentencing recommendation or to refrain from making an unfavorable recommendation in return for the defendant's guilty plea. I will say that sentence bargaining appears to be less widespread in common law countries than does charge bargaining, and that's due in part to the fact that some countries do not have a practice of allowing the prosecutor to make a sentencing recommendation. And it's because of that that it appears that sentencing bargain just simply isn't possible in two countries, because in those countries, prosecutors don't make a sentencing recommendation. In England and Wales, with minor exceptions, prosecutors aren't even allowed to address the court on sentencing matters. And just I'm sure you all realize this, but just to spell out the logic here, why that would matter for sentence bargaining. If a prosecutor can't make a sentencing recommendation, then they can't negotiate with the defendant over what that recommendation would be. And I'll add, the fact that the prosecutors can't make a sentencing recommendation appears to be related to a strong sense in that country that sentencing is a matter entirely within the judge's power and not the prosecutor's power. Scotland doesn't appear to have a practice of sentencing recommendations and thus no practice of sentencing bargaining, though it's unclear whether this is a legal prohibition or merely accepted practice. Sentence bargaining is more complex in both New Zealand and in Australia. Sentence recommendations are permitted in New Zealand, but not in a way that would facilitate a sentence bargain. And that's because prosecutors are allowed and sometimes even expected to tell judge what they think the appropriate sentencing range is, but not to recommend a specific sentence. And because the appropriate range tends to be quite broad, making or having a particular recommendation there is of limited value to defendants. In addition to that, there's evidence that sentencing bargain is just quite rare, perhaps because of that. There's a government report actually addressing the issue, saying that there is no true sentence negotiation, both because it's prohibited by prosecution guidelines and because that country also takes the view that the judge has the sole power to determine the sentence. There was a subsequent government report in New Zealand indicating that under existing practice, negotiations do not include express agreements as to a particular sentence. There were a couple of anecdotal pieces of evidence of prosecutors supporting a particular sentence. I believe it was a sentence proposed by the defendant, and then the report quickly condemned that practice, saying it was inappropriate and it shouldn't happen. I suppose this leaves open the idea that prosecutors can support a defendant's proposed sentence, thus making sentence bargaining possible in New Zealand, but as the government report suggests, it's not common or thought of as appropriate. Now in Australia, this is kind of interesting, there's been some dispute over whether prosecutors have the authority to make a sentencing recommendation. So there's a 2014 case from the High Court of Australia, which, as the name suggests, is the highest court in Australia. It declared that prosecutors should not make any recommendations to the judge about the appropriate sentence. Now, that decision is widely understood as having arisen in the context of an informal and implicit sentence bargain, but that fact is never mentioned in the High Court's opinion. And in the decades since that decision was handed down, it's provoked some criticism in the country. And because the decision was made not on a constitutional basis, but as a matter of common law in the country, the High Court has the ability to make decisions through case law. It's a common law system. But that gave the states and territories in Australia the ability to overturn the decision through legislation, and several of them did pass legislation giving prosecutors the authority to make sentencing recommendations. As a result, sentence bargaining is possible in some Australian states and territories, but not in others. And then the United States, where sentence bargaining is both possible and common. Prosecutors are not only permitted to make sentencing recommendations to judges, but in some US jurisdictions, the sentencing agreement between the prosecutor and the defense attorney can actually bind the judge. So that is to say, the rules of criminal procedure affirmatively authorize an additional type of sentence bargain an agreement by the two parties that a particular sentence is appropriate, and under this type of sentence bargain, the defendant's guilty plea is actually conditioned on the judge agreeing to impose that agreed upon sentence by the parties. Now, the court doesn't have to accept that agreement, but if it doesn't accept the agreement, then the defendant is free to withdraw the guilty plea. Okay, now looking at this chart, you might think that in most countries, prosecutors aren't able to incentivize defendants to plead guilty through negotiations over the sentence that the defendant will receive, but that's actually not true. And that's because although some of these countries don't allow prosecutors to directly bargain over a defendant's sentence, they can indirectly bargain over a sentence by bargaining over the relevant facts. So this sort of practice is sometimes referred to as fact bargaining. Now, under fact bargaining, prosecutors can convince a defendant to plead guilty by negotiating over a statement of facts that'll be tendered to the judge for sentencing. And especially in countries like Australia and New Zealand and England and Wales, where there's quite a bit of case law on what are aggravating and mitigating sentencing factors, the parties can exert a significant, though admittedly imprecise, effect on what sentence will be imposed by agreeing that certain facts are or are not present in a particular case. So, fact bargaining is a common prosecutorial practice across all 5 countries. Australia, England and Wales, New Zealand, and Scotland, they all have a practice of the parties submitting a negotiated statement of facts, which then forms the basis for the judge's decision. Now, obviously, if they can't agree, the judge will resolve disputes over sentencing facts. But as I said, it's common practice to submit a negotiated statement of facts. What's kind of interesting is that of these common law countries, the country that's the most hostile to fact bargaining is actually the United States, which is surprising given that we appear to be both the birthplace and also the most aggressive embracer of the other types of plea bargaining. But there's evidence of this hostility in the history of the adoption of sentencing guidelines in our federal system and in some of our states, where those guidelines were structured in part to ensure that a defendant was being sentenced based on the facts that actually occurred, sometimes called their real offense behavior, and to prevent the parties from bargaining over facts and telling the judge what facts they ought to take account of. That said, although this hostility exists, fact bargaining has been widely documented in the United States. There's little doubt that it occurs, just a little bit of hostility towards it in some quarters. Okay, so having described plea bargaining in common law countries, let me offer a few observations and reflections about plea bargaining and adversarial justice. If you'll recall, when I started speaking, I noted that sort of the premise of an adversarial system is that the parties' competing presentation of evidence and arguments will allow the judge or jury to arrive at the truth. Just so that we're really clear about this premise, the assumption is that the parties will work very hard to find all of the evidence that benefits their side, and they'll make the best arguments available in light of that evidence. So all the judge and the jury have to do is just decide which of the two parties presented better evidence and made better arguments, because the premise is that that's the side that should win. That's the side that's telling the truth. That's the side that would result in a just outcome. Now, of course, this premise is highly contestable. I mean, if one party has more resources or if it hides evidence from the other party, for example, then the judge or the jury might mistakenly convict an innocent person or allow a guilty person to go free. But putting to one side the practical difficulties or these empirical questions about the premise of the adversarial system, the theoretical premise, so the theory of adversarial system, is quite straightforward. I think because the theory behind adversarial justice is so straightforward, it's also quite clear why plea bargaining represents a significant departure from the very foundation of adversarial justice. Rather than presenting all the evidence and making arguments to a neutral decision maker, plea bargaining relies solely on the parties to decide how a case should be resolved. The procedures and protections that ordinarily operate to ensure fairness and accuracy are abandoned. We say that they have been waived as part of the plea bargain. And even the search for truth sometimes falls by the wayside, as some forms of plea bargaining actually depend on obscuring the truth. So my fellow panelist, Thea Johnson, she's written rather eloquently about how plea bargaining encourages deception, including convictions for crimes that are actually a legal fiction, aren't supported by the statutes that the defendants are actually pleading to. And I should add that the abandonment of truth as the objective isn't just an American problem. In those other countries that rely so heavily on fact bargaining, it appears to be an open secret that the agreed upon facts are not necessarily true. They're instead what the two parties are willing to agree upon, and sometimes they will be false, and they're acknowledged to be false. Now, I don't think that anyone seriously disputes the idea that plea bargaining represents an abandonment of adversarial justice. Instead of disputing it, people defend plea bargaining on other grounds. And the two most popular grounds are as follows. First, some say that plea bargaining allows the parties to work together to resolve the case. And because the parties are able to negotiate, so the argument goes, they're able to arrive at fair outcomes. Now, I'll say this argument assumes that the two parties have equivalent bargaining power, but as my fellow panelist Clark Neily has passionately argued before, and I'm sure will do so today as well, plea bargaining dynamics, especially the dynamics in the United States, are so unequal and so tilted towards the government that they're often coercive and thus not only not likely to result in a fair negotiated outcome, but also just not compatible with our country's principles of due process and the rule of law. These unequal bargaining dynamics not only prevent the outcome of a plea bargaining from being fair, they don't seem to fit comfortably within our constitutional structure of individual rights. A second response or a second defense of plea bargaining that's sometimes made is that plea bargaining is necessary because there are too many criminal cases and not enough resources to hold trials. And plea bargaining is doubtlessly more efficient than holding a criminal trial, and the desire to increase efficiency lies at the heart of plea bargaining and other tactics that common law countries have adopted in order to encourage guilty pleas and to discourage defendants from insisting upon their right to a trial. Now, sometimes this second argument is made in hyperbolic terms, claiming that the criminal justice system would collapse and criminals would roam free without plea bargaining, and I've written at some length about how those claims are overblown and how my country's courts could hear far more cases than they currently do, but I don't dispute the fact that as they're currently constituted, American courts can't hold trials for every single crime that's committed. And the same, I assume, is also true of the courts in other common law countries. But while I'm willing to admit that full trials for all defendants aren't practical, I'm far from convinced that plea bargaining, especially in the extreme form that we see in the United States, is the best way to solve this practical problem. And that's because rather than modifying the adversarial justice system to ensure that it's more efficient, plea bargaining abandons adversarial justice altogether. Now, I know that some of today's attendees come from civil law countries rather than common law countries, and so you might not think that the abandonment of adversarial justice is a pressing problem. In fact, you might even see that abandonment as a positive development. But let me suggest that the abandonment of adversarial justice should perhaps serve as a cautionary tale for those civil law countries that have begun to experiment with plea bargaining. I know from the work of American scholars, including my fellow panelist, Jenia Turner, that some inquisitorial systems have begun to experiment with plea bargaining over the past few decades. My understanding is that plea bargaining has gained a significant foothold in a number of countries, including Germany, France, Italy, Japan, Russia. Now, I haven't undertaken my own study of these systems. I do know that plea bargaining takes different forms in these different countries, and so I can't offer detailed opinions about plea bargaining in those countries. But even as someone who's an expert in common law rather than civil law, I can say that the embrace of plea bargaining, especially American-style plea bargaining, doesn't seem to fit comfortably with the foundational premise of an inquisitorial system, right? My understanding is that the judge plays an active role in an inquisitorial system in investigating the case and seeking the substantive truth, right? That's the touchstone of an inquisitorial system. And to the extent that countries seek to replace the judge's investigation with party-based negotiation, that seems to me, as an outsider, to be no less an abandonment of that system's core values than the abandonment we've seen in common law countries. So to the extent that civil law countries are exploring plea bargaining as a possible path to efficiency, let the common law countries serve as a cautionary tale. While pursuing efficiency, make sure that you also seek to preserve the fundamental principles of the inquisitorial system and don't allow efficiency to displace other important principles and values. Let me end my remarks by saying that as a general matter, I think we should all be quite skeptical of efficiency as a principal value for the courts and the law, especially for criminal law. The most efficient systems are going to be those systems that don't afford defendants any rights or any process, systems that will allow government actors to detain people based on little more than speculation or suspicion. And I'll add that 10 years ago, I would have assumed that such a warning was unnecessary, but unfortunately, recent events have reminded me that it's important to reaffirm that all persons deserve legal process, even when that process isn't efficient. Okay, so I'm going to take this opportunity to welcome my colleague Jenia Turner to deliver her remarks. Professor Turner is the Robert G. Story Distinguished Faculty Fellow and Amy Aboudware Centennial Professor in Criminal Law at the SMU Dedman School of Law in Dallas, Texas. Professor Turner has written extensively about comparative and international criminal law and procedure, including the law surrounding plea bargaining. In 2009, she published a book, Plea Bargaining Across Borders, which explores plea bargaining in several national and international jurisdictions. She's also the co-editor of the Oxford Handbook of Criminal Process and the casebook Criminal Procedures, Cases, Statutes, and Executive Materials. Professor Turner is a member of the American Law Institute and an associate member of the International Academy of Comparative Law. Professor Turner. Thank you.
Good afternoon, everyone. First, I'd like to thank the organizers of this fabulous conference for inviting me to present and for helping organize this panel. I'd like to thank Carissa Hessick as well for her very thoughtful remarks and for inviting me to the panel. It's an honor to be here. And I look forward to your questions and to our discussion. And as someone who is interested in comparative criminal procedure, I really hope that when you ask questions, you also make comments about whether plea bargaining is happening in your jurisdiction and what problems arise in your jurisdiction, because we are all very interested in that dialogue. So with that, I want to turn to the topic of my presentation, which is transparency in plea bargaining, and why it's a critical guarantee of procedural fairness and integrity. I will address three main questions. So first, why is plea bargaining a non-transparent process? Second, what could we gain by making the process more transparent? And third, how could we make the process more transparent without imposing undue burdens on our legal systems? So as I discuss these questions, I'll focus primarily on the United States, as I'm most familiar with it, but I will also try to make occasional references to continental European systems, since the goal of this conference is to encourage comparative dialogue. So let me begin with some background. As you've heard from my panelists, in the United States, plea bargaining is the dominant way of resolving criminal cases today. More than 95% of convictions in our courts are the product of guilty pleas. And as you know, across the world, forms of negotiated justice, conformidad, patejamento, ple de culpable, Absprachen, and the like, have also spread as part of a broader trend of pursuing faster and less expensive criminal case dispositions. So in 2017, the organization Fair Trials studied systems of negotiated justice in 90 countries around the world. It found that more than 2/3 of the countries studied, 66 out of 90, authorized some type of negotiated justice in criminal cases. Interestingly, this was up from only 19 countries in 1990. So what are the reasons for this expansion of forms of plea bargaining around the world? And the main reason given is efficiency. As Carissa already discussed, in the early 1970s, in a US Supreme Court case called Santobello, which she talked about, the Supreme Court explained that plea bargaining is highly desirable because it leads to prompt and largely final disposition of most criminal cases. 17 years later, in 1987, the Council of Europe encouraged European countries to adopt consensual mechanisms in order to speed up criminal case processing. Now, of course, efficiency, as again, Carissa mentioned, efficiency in the criminal process is valuable up to a point, as long as it does not undermine fairness and the search for truth. Efficiency can allow defendants, victims, and attorneys to obtain quicker dispositions. It promotes predictability and finality. It also frees up more resources for the criminal legal system to pursue other cases. And in this way, it can support the enforcement of criminal law, and it can help advance its ultimate goals, whether that be retribution, deterrence, incapacitation, rehabilitation. However, efficiency is not the only or even the most fundamental goal of the criminal process. Fairness, equal treatment under the law, and the search for truth are all core values. And efficiency should not be pursued to the point at which it undermines these values. It would do little good if a criminal legal system resolves cases efficiently, but it does so with a high rate of errors, without adequate due process, or with no regard for equal treatment under the law. When this happens, the criminal legal system becomes unmoored from its constitutional foundations, and it's no longer able to accomplish its broader goals. Now, US courts have recognized this point to some extent, and they have placed some limits on the pursuit of efficiency through plea bargaining. For example, judicial review of guilty pleas takes time, but our courts have required it because it helps advance fairness in the process. It helps minimize the risk that innocent people might be pressured into pleading guilty, that defendants might plead guilty without understanding the consequences, or that guilty pleas might not accurately reflect the true facts in the case. Now, unfortunately, at least in the United States, courts have not regulated plea bargaining sufficiently to ensure that it's consistent, fully consistent with fairness and truth-seeking. And as you have heard and will hear from my fellow panelists, U.S. plea bargaining has been widely criticized for its coerciveness, for effectively forcing even some innocent defendants to plead guilty, and for undermining the search for truth. And unfortunately, US courts and legislatures have not placed restrictions to address some of these issues. For example, they haven't placed restrictions on the level or type of plea discounts that defendants may be offered. So you could have a defendant facing 5, 10, or 20 years or more after a trial conviction and be facing probation or just a very short sentence after a guilty plea. And I know my fellow panelist, Clark Neily, will talk about that. But courts have not regulated that in the United States. They have also not limited the types of cases that can be plea bargained, so therefore you can plea bargain in homicide cases or rape cases. And while a minimal level of judicial review of plea bargains does exist, US law does not require judges to scrupulously examine the factual basis of guilty pleas. So these are all problems with plea bargaining, but today I want to discuss another aspect of plea bargaining, its lack of transparency, which can also undermine fairness and the search for truth in the criminal process. So, in what ways does plea bargaining lack transparency today? So first, as Carissa Hessick mentioned, negotiations occur out of the public eye and usually out of court. They typically involve only the prosecutor and the defense attorney, while the most affected persons, the defendant, as well as any victims, are not personally present during the negotiations. They might sometimes be present, but not always. In most US jurisdictions, as well as some European jurisdictions, judges are not directly involved in the negotiations either. And in addition, in the United States, although not in Europe, negotiations often occur without adequate disclosure of relevant evidence to the defense. In the United States, plea offers are often not documented, and even if they are, the documentation stays in the file of prosecutors, which are close to anyone else. And even the final plea agreements are not always in writing or placed on the record with the court. So only about half of the states in our federal system require that they be placed in writing and be placed on the record. Now, it's true that plea hearings are public. At a plea hearing in the United States, the court will hold a public hearing to ensure that the guilty plea is voluntary, knowing, and in most states that it's factually based. However, plea hearings are often very brief and perfunctory, and they often fail to reveal key elements of the negotiations and concessions that shape the outcome of the case. So, why has plea bargaining remained an opaque process despite a broader commitment in our criminal justice system to public criminal proceedings? Historically, as Will Ortman discussed already, a lot of it had to do with the way plea bargaining initially developed, informally, in the shadows, without any judicial or legislative authorization. But today, several legal and policy reasons are typically offered in favor of continuing to protect certain aspects of plea bargaining from public scrutiny. The first reason is that confidentiality is necessary to foster candor in negotiations. And the idea here is that if the parties had to conduct negotiations in public, they might not be fully forthcoming in their positions, and they may have trouble reaching compromise. A second reason given for the opacity of plea bargaining is that it protects prosecutorial discretion, and specifically the discretion to exercise mercy. In other words, non-transparency gives prosecutors greater freedom to reduce or dismiss charges and to provide leniency in the face of rigid criminal laws in the US. Now, this justification for non-transparency is more peculiar to the US, where prosecutorial discretion is quite broad, to the extent that some continental European systems follow the principle of mandatory prosecution. This justification does not work for them as well. A third reason for non-transparency in plea bargaining is that it helps shield cooperating witnesses and defendants from retaliation. If plea agreements were public, and if they documented cooperation by defendants, then cooperating defendants could be subject to threats and physical harm. This can be particularly problematic in organized crime cases. Likewise, when it comes to discovery before plea bargaining, if witness names and statements are disclosed to the defense before plea negotiations, it's feared that the information could be abused by defendants to intimidate witnesses. A fourth reason is a concern that transparency is simply too burdensome. So having to memorialize plea offers or having to place plea offers on the record, for example, would mean taking away time from completing other cases. Now, while these arguments in favor of confidentiality have some merit, I will argue that they do not justify the level of non-transparency we see in plea bargaining in the US today. And I think our criminal process would benefit in many ways if we improve transparency in plea bargaining. And let me explain why. So first, greater transparency would be consistent with our constitutional commitment to open criminal trials. The First and Sixth Amendments of the US Constitution, as well as the common law tradition, provide for the right to public criminal proceedings. The law on public access to criminal proceedings recognizes that transparency helps ensure fair treatment at trial, as well as at plea and sentencing hearings. Our Supreme Court has explained judges, prosecutors, and defense lawyers will all perform more responsibly in an open court than in secret proceedings. Likewise, the European Convention of Human Rights and various European court decisions have similarly emphasized the importance of transparency. So, as many of you know, Article 6.1 of the Convention provides criminal defendants with the right to a fair and public hearing and a public pronouncement of the judgment. And in a range of cases, such as Ripan versus Austria and Tirsi and others versus San Marino, the European Court of Human Rights has explained that the right to a public trial is necessary to guarantee fairness in criminal cases, to establish the truth, and to maintain public confidence in the courts. And let's see. In Natsvilishvili versus Georgia, the European Court of Human Rights held that transparency and accountability are important not only in contested trials, but also in cases resolved through plea bargains. The court held that the content of any plea bargain and the fairness of the manner in which it had been reached between the parties must be subjected to sufficient judicial review, and to enable sufficient judicial review, the parties have to create a written record of the bargain, and they must present it to the court for consideration. Such a record makes it possible to have the exact terms of the agreement, as well as of the preceding negotiations, set out for judicial review in a clear and incontrovertible manner. The German Constitutional Court has also stressed the value of transparency, even in negotiated criminal cases. It has required that trial courts document the gist of the negotiations and the ultimate terms of any agreement reached. So, one argument is that enhancing transparency would respect the broader constitutional commitment to open criminal proceedings. Another argument is that transparency in plea bargaining is also important because it strengthens oversight in the criminal process and it helps to promote equal treatment of defendants. When deals are not properly documented, it's difficult to detect and therefore to address when defendants are not treated fairly in the process. This is a real concern because some studies in the US have found that plea bargaining outcomes for similarly situated defendants vary on the basis of the defendant's race and on the defendant's wealth. Now, if plea bargaining offers and agreements were made more transparent, for example, by documenting them in searchable databases that are available to the attorneys, this could help promote fair plea bargains and equal treatment of defendants. And as you know, professionals have access to such databases in areas that are much less consequential, for example, real estate transactions or car purchases, but we still lack them for criminal legal decisions that affect people's liberty. Another reason to support transparency is that it can also help us better understand the problem of the trial penalty, a problem that my fellow panelists Carissa Hessick and Clark Neily have discussed in the US context. Professor Thomas Weigen has discussed in the context of German criminal procedure. So what is this problem? When a defendant rejects a plea offer and proceeds to trial, is convicted, and receives a much harsher sentence than what the defendant was offered in a plea, this penalizes his exercise of the constitutional right to a trial. It also increases the risk that an innocent person would plead guilty to avoid the prospect of a trial penalty. And we know from US exoneration data that about 20% of exonerations stem from cases in which defendants pleaded guilty. And I know that Mauricio Duce is here in the audience, and I wanted to use this moment to recommend his excellent chapter on plea bargaining and wrongful convictions that talks about why plea bargaining increases the risk of wrongful convictions, one of the issues being the trial penalty. But in short, we know that innocent defendants sometimes plead guilty, and research suggests that the risk of a sizable trial penalty is an important contributing factor. Now, while we know that the trial penalty can be significant, debate continues about how large it is. Varies from jurisdiction to jurisdiction, from court to court. We know that there's a difference between the average sentence for defendants who pleaded guilty versus those who went to trial, but some might object that we can't be sure that these cases are truly comparable. The cases of the people who plead guilty might be different in important respects from those who go to trial. So there's still this debate about the size and the frequency of the trial penalty because we do not have access to records that would allow us to compare in the same case a plea offer to the sentence received after trial after a defendant rejects the plea offer and chooses to proceed to trial. Okay. Another reason to improve transparency is that it can also help with another problem of plea bargaining, namely that plea bargains are often not based on the true facts of the case. As I mentioned earlier, many US jurisdictions, unlike continental European systems, still do not require the prosecution to disclose police reports, witness names, or witness statements before plea negotiations or a guilty plea. So defendants and their attorneys in those jurisdictions are bargaining in the dark without understanding the full extent of the evidence that the prosecution has. And requiring broad pre-plea disclosure of the evidence is needed to ensure that plea bargains are fair and that guilty pleas are truly informed. Now, non-transparency also allows the parties to agree to omit certain facts and certain charges from the final agreement. And in this process, as Thea Johnson has argued, sexual assault, for example, will sometimes be negotiated down to simple assault, or gun charges in a drug trafficking case will get dropped. Now, this type of fact bargaining is formally prohibited in many continental European systems, but it persists in the United States largely because of broad prosecutorial discretion, strict mandatory penalties for certain charges, and the belief of the parties that these penalties would be disproportionately harsh in certain cases. However, these fact bargains conflict with the search for truth, and making plea bargains more transparent would not entirely resolve this tension between the search for truth and proportionate sentencing. Only a reform of our sentencing scheme could do that. But it could at least provide a more deliberative and inclusive process to help address the tension by allowing the court, any victims involved, and the public to understand the true facts behind the case and to provide input on the appropriate resolution. And a notorious case where that did not happen is the picture that you see on the screen, Jeffrey Epstein, the wealthy financier who was accused of trafficking and sexual assault, and was able to reach a plea deal that was kept secret for a long time from his victims and the public. So, can we improve transparency without imposing undue practical burdens on our legal systems? I think we can. We can take measures that expand accountability and fairness in the process without harming the legitimate interests of witnesses and cooperating defendants, and without overburdening the system. So let me briefly address the kinds of measures we could take. First, we can adopt universally a requirement that many states, about half of the states and the federal system, already have on their books, that plea agreements be in writing and be filed with the court. As I mentioned earlier, the European Court of Human Rights and the German Constitutional Court have also supported this documentation requirement. It helps to reduce disputes about the terms of the plea agreement, and it improves fairness. To address concerns about intimidation of cooperating defendants in specific cases, plea agreements can be sealed, and this is already done in the federal system, when there's a credible risk of harm to cooperators. Now, we can also require that plea offers be documented. Now, this requirement does have some administrability costs. For example, in Germany, the requirement that the gist of formal negotiations be documented has apparently been seen by some courts and practitioners as rather burdensome. And some empirical studies suggest they have found that it has not been consistently followed in practice. But in the United States, there are some early signs of success with greater documentation of plea offers, as a few prosecutors' offices in North Carolina, in Massachusetts, and in Texas have begun documenting plea offers in digital platforms, and they have not found it impractical. So I'm showing you an example here of the type of information that one county in North Carolina, the district attorney's office, the prosecutor's office, used to document plea offers. So this is the kind of information that their database would include, not just the plea offer itself, but also various key facts in the case, or key features of the case. So these platforms, being digital, could also be made searchable by both prosecutors and defense attorneys, so they can ensure that they're aware of plea precedent and that plea negotiations are fair. And also researchers could be given access to study these databases to understand the magnitude of the trial penalty, as they could compare records of rejected plea offers in the same case to subsequent post-trial sentences. Now, another way to expand transparency is to require the parties to share evidence before plea negotiations. And here's an example of a platform used in Texas to share digital evidence, where Evidence is made available to the defense before any plea negotiations take place. Now, in Europe, evidence is routinely disclosed to the defense early in the process, so this is also an area where we can learn from our European counterparts. And as I said, some jurisdictions in the US are already moving in that direction, so states like Texas, New York, North Carolina have changed their laws to require earlier and broader discovery. And the use of digital platforms has helped facilitate such discovery. And as for the safety of witnesses, which is a legitimate concern, but that has been protected by allowing prosecutors to redact sensitive witness information and, if necessary, to apply for a protective order with the court. And of course, early discovery has allowed defense attorneys to provide informed advice to their clients about the reasonableness of a plea offer and to help ensure that guilty pleas are voluntary and knowing. Now, I will add a caveat. Unfortunately, empirical studies have found that defense attorneys are not always taking advantage of this discovery before negotiations in the United States, or not all of them do, but these attorneys remain a minority, and on the whole, early discovery has improved fairness and reduced the risk that an innocent person might plead guilty. Okay, so a final way in which transparency could be improved is to increase judicial scrutiny of plea agreements. We can require that at the plea hearing, judges probe more carefully into the terms of the bargain and the facts of the case. In most cases today, plea hearings tend to be brief and perfunctory. Studies have found that plea hearings in the US last on average between 9 and 14 minutes in felony cases, and even less than that, so in misdemeanor cases. In misdemeanors, it's something between 6 and 8 minutes on average. And as scholars have noted, they truly are perfunctory. As someone said, as long as the defendant parrots the correct phrases, the judge is unlikely to scrutinize the plea any further. So instead, what I would argue is that we should require something that the more scrupulous judges in the US already do, going over the details of the plea agreement with the defendant on the record to ensure that defendants adequately understand the agreement and that the agreement contains no unduly coercive terms. Judges would also question the defendant more thoroughly about the facts of the case to check whether the guilty plea is supported by a strong factual basis. Victims could also be given the opportunity to be heard at the plea hearing, as an increasing number of states are requiring. Now, in Europe, judges already have the advantage of having a detailed investigative file before them to help them evaluate the factual basis of a guilty plea. We don't have that in the United States. But even in Europe, careful questioning of the defendant and perhaps even some victims and witnesses at the hearing would be consistent with the principles of orality and independent judicial scrutiny into the facts. We could also involve judges directly in the negotiations with the parties. This is the practice in Germany, and in many states in the US, it's becoming more common across states in the US. Now, some jurisdictions in the US still prohibit judicial involvement, including the federal, judicial involvement in the negotiations, because there's a concern about the potential for bias or coercion by judges who are involved in the negotiations. However, US states such as Connecticut, for example, have shown that this problem can be managed by using a different judge for trials if plea negotiations fall apart. And interviews of judges and attorneys in jurisdictions where judges are involved in the negotiations have shown that such involvement, when properly regulated, promotes fairness and accuracy by interposing a neutral figure between the parties. So therefore, more states in the US, as well as in Europe, could involve judges more actively throughout the negotiation process, and they can preserve the judge's neutrality by appointing a different judge to oversee the trial if negotiations fall apart. In brief, There are several practical ways in which we can enhance the transparency of negotiations in criminal cases. Such transparency will come at some cost. It will take some extra time to document plea offers and plea agreements, although digital tools make the process easier. It will also take some time and effort for judges to be more actively involved during the negotiations and again at the subsequent plea hearing. But as we consider these costs, we should also consider a more fundamental question. What are the costs of having a non-transparent process? Can we afford a system that values speed over fairness? Thank you.
Thank you very much, Thea. Before I introduce our next speaker, I just wanted to remind everyone to please submit any written questions and also any requests to speak for the Q&A session through the app, and I'll be keeping track of that. Okay, so next we're going to hear from Thea Johnson, who's the Associate Dean for Faculty Research and Development and a Professor of Law at the Rutgers School of Law in Camden, New Jersey. Professor Johnson has not only written extensively about plea bargaining, but she also served as the reporter for the American Bar Association's recent task force on plea bargaining. She holds a bachelor's degree magna cum laude from Harvard University and a law degree with honors from the George Washington School of Law. Professor Johnson joined the faculty at Rutgers in 2020 after 3 years as a law professor at the University of Maine. She has also previously interned at the United Nations International Criminal Tribunal for Rwanda and Tanzania, and worked as a staff attorney for both the Legal Aid Society of New York City and the Federal Defenders of New York, and she served as a Gray Fellow at Stanford Law School. Thea?
Great. Well, thank you so much for having us. This is really an exciting conference. So thank you to the organizers. Thank you to Carissa for organizing this panel. You're going to hear a lot of the same themes in my talk that you've heard from my fellow panelists. But I think, the repetition is because the issues are very real in the US today. So, as you've already heard, plea bargaining in the United States produces, at least in part, inaccurate and/or false guilty pleas, by which I mean sometimes in the US system, innocent people plead guilty, or people who are legally innocent of the charged crime plead guilty. And today I want to focus my remarks on what I see as some intertwined barriers to solving the problem of inaccurate and false guilty pleas. First, the courts, starting with the US Supreme Court, have accepted the ascendance of plea bargaining in the US on a faulty assumption that when a defendant, with the advice of competent counsel, waives their right to trial and accepts a plea, that they do so only when they are guilty of the crime. To put it another way, courts behave as though it is only the guilty that are pleading guilty. Second, embedded in this assumption is that defense attorneys will not allow factually or legally innocent clients to plead guilty, but will instead advise them to proceed to trial. And I see this as using a problem of adversarial tools to solve what is essentially sort of a US-style inquisitorial problem. Courts assume defense attorneys will prevent false and inaccurate guilty pleas, even though their role is purely adversarial. And third, because courts rely on these incorrect assumptions, namely that a defendant's advised by competent counsel will not falsely condemn themselves, the courts require no meaningful proof of the defendant's guilt to accept a plea. They merely take the defendant at his word that he is guilty. As a result of these assumptions, we have a profound lack of evidence in the vast majority of U.S. criminal cases. And since this is an evidence conference, let me emphasize my underlying concern here. The U.S. system needs more evidence. In a system dominated by pleas, we simply produce insufficient evidence. As a result, we have no confidence that the people who are pleading guilty are guilty. Indeed, without a full adversarial trial, we just have inadequate mechanisms for even discovering the truth in a case. I argue that we should abandon our reliance on waiver, which I'll talk about in a moment, and defense attorneys as the means for assuring the accuracy of pleas, and think about expanding the guilty plea requirements to include, as Professor Turner just talked about, some meaningful evidence production. In making these arguments, I draw from the work of many of my fellow panelists and other scholars in the field. So as Professor Hessick noted, in the US criminal system, defendants can waive their right to trial, including all the rights associated with trial. And the standard for such waivers generally requires that the defendants do so knowingly and voluntarily. And although it is not officially included as a requirement of waiver, U.S. courts have often relied on the fact that a defendant was represented by competent counsel in assessing whether he waived his rights knowingly and voluntarily. And the Supreme Court case, which we've heard about already today, that explained that a defendant can waive the right to trial knowingly and voluntarily, that case is called Brady versus United States. And at this point, it is many decades old. But I want to focus my comments a bit on a famous quote from Brady that I argue still animates much of the court's approach to plea bargaining. And this is the quote. Quote, "We, i.e. the Supreme Court, would have serious doubts about the case at hand if the encouragement of guilty pleas by offers of leniency substantially increased the likelihood that defendants advised by competent counsel would falsely condemn themselves. But our view is to the contrary and is based on our expectation that courts will satisfy themselves that pleas of guilty are voluntarily and intelligently made by competent defendants with adequate counsel, and there is nothing to question the accuracy and reliability of the defendant's admissions that they committed the crimes for which they are charged." As Clark Neily will explain in his remarks, we know, however, that innocent people do condemn themselves in the United States through false guilty pleas. This, by the way, I should note, doesn't just impact the wrongfully convicted defendant, but also downstream actors who are affected by these false pleas, including other innocent parties that the defendant might have implicated to secure the deal, or victims of the actual perpetrator who was never caught because an innocent person pleaded guilty. In a study by the Center on Wrongful Convictions, they examined 85 wrongful convictions in a single state over a short period of time, and they found in these cases, quote, "the actual perpetrators were on a collective crime spree that included 14 murders, 11 sexual assaults, 10 kidnappings, and at least 62 other felonies." Additionally, guilty pleas sometimes plead guilty to crimes they didn't commit in order to secure a favorable deal. As I've written about, some people plead guilty to non-existent crimes for the benefit of the deal. This means that defendants admit to offenses that have no relation to their actual behavior. And we also know that people plead guilty to crimes for which they have valid legal defenses. All this indicates that a not insubstantial portion of guilty pleas fail to represent the truth. And there are many reasons for this, and I won't enumerate them here, although I do really recommend Professor Hessick's terrific book, Punishment Without Trial, which is a holistic view of plea practice in the US, and can give you an understanding of many of the issues that got us here. For now, it's enough to say that the court's assessment in Brady that only guilty people plead guilty is wrong. And with this foundation, I will discuss sort of two major areas. So first, I want to explain why a knowing and voluntary plea with competent counsel's assistance is insufficient to guarantee a truthful guilty plea. While this may seem obvious to academics, I think it's important to make the point explicit because U.S. courts have embraced this idea that a guilty plea is legitimate if made knowingly and voluntarily based on faulty assumptions about the defendant's guilt. Further, I want to emphasize that the U.S. system has placed far too much emphasis on the defense attorney as delivering accurate outcomes. Even in a perfect world, where a defense attorney has all the resources we can imagine, they cannot and should not guarantee that an innocent man won't condemn himself, and we shouldn't pretend that defense attorneys serve this mythological role. Second, I will argue that because a knowing and voluntary waiver is insufficient to guarantee an accurate conviction, the U.S. system should implement additional proof requirements before accepting guilty pleas that's separate and apart from the defendant's waiver of his rights. Others have made this argument, but I echo it here in light of the specific issues with false and inaccurate pleas. An expanded guilty plea requirement would pave the way for introducing truth-seeking mechanisms associated with trials to be used during plea bargaining and the guilty plea phase. Indeed, as Professor Ortman has argued in a paper, defendants should, for instance, retain their right to confront witnesses against them, even when they opt to plead guilty. Once we acknowledge that guilty pleas are often inaccurate, we can explore methods to increase their accuracy. So moving to sort of part one of my argument, as professors Christopher Slogan and Kate Weisberg wrote in a recent article on waivers, quote, "The state's goals during plea bargaining are fundamentally twofold. Convicting a guilty person, justice, without the expense of trial, efficiency. But when a person pleads guilty before a judge, in the U.S., we ask very little of the state, particularly about the facts of the case or even what investigation it performed. In most places in the U.S., the state must give a brief recitation of the facts to establish a factual basis for the plea. But as Professor Turner has already discussed, and she has a terrific article on this subject, in some places, the factual basis happens in just minutes. And in fact, in many places, what we see is that the entire guilty plea hearing, including the recitation of the facts, all the procedural requirements, will take somewhere in the realm of 10 minutes for a felony case. Further, at the time of the guilty plea, what we do in the U.S. is we turn to the defendant to establish that he is guilty. We ask him if he's guilty, and then we accept his statement of guilt and trust that he is genuinely pleading guilty to the crime he committed because he has a defense attorney standing there beside him. And I put aside here in the U.S. that there are millions of defendants who do not have an attorney at the time they plead guilty, but I focus only on those who do because of the court's trust in defense attorneys on the waiver issue. Further, the state will ask the defendant to waive rights that scholars have noted detract from the state's objective of convicting only guilty people. For instance, defendants are asked to waive their right to receive evidence of their innocence. They are regularly asked to waive their right to appeal to review the conviction for errors. So although the state is required to prove a criminal case beyond a reasonable doubt at trial, they have no proof obligations at the guilty plea, and relieve themselves of any appellate review through the waiver process. Instead, the burden of proof appears to shift to the defendant to demonstrate he's guilty through his admission of guilt. And I argue that this is because courts already think he's guilty. As Professor Josh Bowers has argued, the U.S. Supreme Court jurisprudence on plea bargaining has focused on protecting the defendant from unfair surprise, but not protecting the defendant from substantively incorrect results. This is because they think the results are correct, if not always fair. But as I've noted, we know that innocent people plead guilty. We know that people plead guilty to crimes they didn't commit. And here is why a knowing and voluntary waiver under the guidance of competent counsel won't stop this problem. A knowing and voluntary waiver only requires that the defendant understand the terms of the offer and that he hasn't been coerced into taking the offer. It is nearly impossible for a defendant in the U.S. to show coercion. As my fellow panelists have discussed, and there's lots of writing on this in the United States, the things that we might see, academics, many lawyers, even some judges might deem coercive are just well accepted in the U.S. Therefore, the waiver requirement only assesses really whether the defendant understood the choices before him and made an informed decision about those choices. This is why the Supreme Court focuses on unfair surprise as the heart of plea bargaining jurisprudence. The presence of an attorney does not prevent a defendant from producing a false or inaccurate plea. Putting aside the reality that defense attorneys in the U.S. are generally under-resourced and overworked, even if we imagine the perfect attorney, one with plenty of time, plenty of money, a terrific investigator, the assumptions underlying the Brady case still aren't true. First, even well-resourced defense attorneys have little ability to push back against the state's most coercive tactics. Second, and more importantly, defense attorneys are not required to make sure that the outcome of the conviction is accurate or that innocent people don't condemn themselves. Defense attorneys in the U.S. are not even required to tell a man they know is innocent or they know has a valid legal defense not to take the plea and to proceed to trial. And in fact, in some cases, such advice may be malpractice. In an adversarial system, the defense attorney represents the client's interest, and the client's interests are not always truth. For many guilty clients, they may not want a truthful or accurate outcome, which is an important part of my argument. Truth is not meant to benefit the defendant. It's not meant to benefit even the victim. It's meant to benefit everyone else who relies on the system for truthful outcomes. Truth might well be at odds with the role of the defense attorney, which is why it is so problematic that we accept the assumption that the defendant, represented by competent counsel, will produce an accurate outcome. At the guilty plea phase, it is the obligation of the court system, not the defendant, to produce accurate outcomes precisely because we are abandoning the full array of adversarial procedures that allow the two parties, defense and prosecutor, to duke it out in court. As Professor Hessick noted in her talk, plea bargaining represents an abandonment of adversarial justice. Yet we are still using the tools of a bygone system, in this case reliance on defense attorneys, to ensure truth. But it doesn't work. With this in mind, I now turn to my second argument, which is that understanding that we have an issue with producing truthful pleas in the criminal system, we should expand the requirements at the time of waiver to include some development of facts that support the accuracy of the plea. I am not the first to make this argument, but in light of my concerns specifically about the court's assumptions about waiver, defense attorneys, and truthful pleas, I echo these calls to rethink what the guilty plea looks like. It should not be a trial, but it should be something more than what we have now. I think many of the mechanisms adopted by countries with historically inquisitorial systems gives us a good starting point. And here I draw from Professor Turner's terrific book chapter, Limits on the Search for Truth in Criminal Procedure, a Comparative View, which I recommend. For instance, as many people I'm sure in this room know, many countries now allow a defendant to accept a guilty plea, but only after rather extensive investigation by law enforcement. Law enforcement also asks in certain places the defendant for information about the case that they should look into before making a decision. This stands in contrast to many of the pleas in the US, particularly in state courts, which come very, very early in the case before anyone has had an opportunity to investigate. In my time as a defense attorney, I never once heard a prosecutor ask the defendant or me, the attorney, what information it should look into. In some inquisitorial systems, prosecutors have a duty to discover both exculpatory and inculpatory evidence. Further, in many of these systems, prosecutors, of course, create a dossier of evidence, which is shared with the judge and the defense attorney, giving all the parties an ability to see the extent of the state's investigation. And further, judges have some duty to establish the truth of the case before accepting the plea. These are just some of the mechanisms we could consider importing to the US to develop the record before the guilty plea. We can also consider adapting our adversarial system for the reality of the system we have now. As I mentioned, Professor Ortman has suggested allowing defendants to depose witnesses in line with their constitutional right to confront witnesses. Although depositions are a regular feature of civil litigation in the US, they are rarely allowed in criminal litigation, with few exceptions. They could do a lot of work towards understanding the truth of the case. Professors Eric Fish and Chesa Boudin, who was the former district attorney for San Francisco, just published an article in which they suggest strengthening the many pretrial adjudication measures that already exist in the US, like preliminary hearings, grand jury proceedings, and suppression hearings, all things that in the current system have largely atrophied. In this way, by strengthening them, we could increase the pretrial record that supports conviction. By the way, we have some experience in the US with developing the record at plea bargaining. We allowed defendants at times to plead guilty, but also maintain their innocence, basically say, I agree to plead guilty, but out loud, I'm going to say on the record, I'm innocent. We allow defendants to do that in what is known in the US as an Alford plea. And those pleas are meant to be supported by a more robust factual record than a plea in which the defendant acknowledges his guilt. In those cases, the court may require testimony from a police officer or other evidence of guilt before allowing the defendant's plea to proceed. This is because we do not have the confession by the defendant to affirm the truth of the conviction. Perhaps we should see all pleas as a sort of Alford plea, one in which the defendant agrees to accept a deal offered by the state, but the state now has to provide some proof that the defendant committed the crime for which he is pleading guilty. Two final issues I'll address briefly. First, in this talk, I am not proposing a specific burden of proof for this stage of the case, although you would have to decide on one. Obviously, proof beyond a reasonable doubt would not be appropriate. Such a burden does, in my view, require the full experience of trial. But any burden of proof on the state to produce evidence of guilt would be much better than what exists across the U.S. now. Professor Talia Fisher, who will present later this week, and other scholars have written about ways to experiment with the burden of proof at plea bargaining. For our purposes today, I only note that there are interesting and realistic proposals for how you could deal with the burden of proof issue. Secondly, as I noted before, this practice may end badly for some defendants in the short term, right? It may end well for others, but there's certainly the risk it ends badly for some defendants in the short term, and I acknowledge this. Defendants may want a guilty plea that is not truthful or accurate. We can imagine many reasons for such desire. If the plea is made knowingly and voluntarily, but without a meaningful factual basis, in my view, the court should reject such a plea. It strikes me as important that truth and accuracy have some value, even if that means that defendants may be hurt. I think, perhaps too optimistically, that defendants and victims will eventually benefit from a system that values truth, and I feel quite confident that the public will benefit from such a system. Plea bargains theoretically exist to bypass the full process for defendants whom the system confidently believes are guilty. When an innocent person surrenders their rights to trial and pleads guilty, when someone pleads guilty to a crime they didn't actually commit, this represents, in my mind, a fundamental failure of the plea system. We sacrifice the trial process precisely because we are saying we are convinced of the result's correctness. Consequently, a wrongful or inaccurate conviction by plea constitutes a more severe indictment of the justice system than inaccurate convictions after trial, making it imperative to address the true costs of these convictions through plea bargaining. Thank you so much.
Okay, great. Many thanks to Professor Johnson. I'd also like to thank all of you who have already indicated via the app that you would like to ask a question by taking the floor or submitted a written question. For those of you who are submitting written questions, it might be best to indicate which speaker you would like to have answer unless you are trying to ask everyone. So, our last speaker of today, Mr. Clark Neily, is Senior Vice President for Legal Studies at the Cato Institute. In that role, Mr. Neily oversees significant legal work on constitutional law, overcriminalization, coercive plea bargaining, police accountability, and gun rights. In addition to his work at Cato, Mr. Neily has taught constitutional litigation and public interest law as an adjunct professor at the University of Texas and George Mason's Antonin Scalia School of Law in Arlington, Virginia. He holds both a bachelor's degree and a law degree from the University of Texas at Austin. Before joining Cato in 2017, Mr. Neily served as a senior attorney and constitutional litigator at the Institute for Justice and director of the Institute's Center for Judicial Engagement. Mr. Neily?
Good afternoon. I'd like to join my fellow panelists in thanking the organizers of this event. It's such a pleasure to have the opportunity to speak to you all about such an important topic in such a wonderful city, which I think all of us have somewhat fallen in love with. And as the last speaker, I'd like to thank all of you for still being in the room. I'm pretty confident if this event were being held back home, the number of people in the auditorium would be a lot less. So thanks for that. In February of 2020, I was contacted by a British solicitor who was representing a British-Nigerian dual citizen whom the Justice Department was seeking to extradite to the United States, where he'd been indicted for alleged financial crimes. I was asked to provide my professional opinion as to whether the U.S. justice system still provides a fair hearing to criminal defendants as required by Article 6 of the European Convention on Human Rights and British extradition law. My answer to that question was an unequivocal no. First, because plea bargaining has become so pervasive in America that any defendant extradited to the United States will almost certainly be subjected to it. And second, because it is impossible to guarantee that the plea process the defendant experiences will be free of coercion. What you can be certain of is that there will be no meaningful effort on the part of American judges, prosecutors, or other system actors to ensure that efforts to induce a guilty plea will be free of coercion. As noted by my fellow panelists, over the past 100 years, plea bargaining has almost completely displaced trials as the mechanism by which criminal charges are resolved in America. Indeed, the U.S. Supreme Court has acknowledged that, quote, criminal justice today is for the most part a system of pleas, not a system of trials. And so effective have American prosecutors become at inducing trial waivers that 98.3% of all federal criminal convictions come from guilty pleas rather than constitutionally prescribed jury trials. I find that figure deeply suspicious, and I hope by the end of this presentation you will as well. My thesis consists of 3 basic points. First, coercion has no legitimate role in plea bargaining. A coerced plea is both unlawful and invalid. Second, coercion is all but inevitable in any system that depends significantly on plea bargaining to resolve cases. Thus, where plea bargaining has become pervasive, as in America, it is all but certain that coercion will eventually become coercive as well. Third, and finally, American-style plea bargaining features an insidious paradox, which is that while we can conclusively demonstrate the presence of coercion in the system writ large, it is nearly impossible to demonstrate the existence of coercion in any particular case. The result is a system with a significant but unquantifiable amount of pathology that I believe thoroughly undermines the legitimacy of criminal adjudication in the United States. My talk will be divided into 2 parts. First, I will explain why, despite the fact that we can rarely demonstrate the presence of coercion in any specific case, we can nevertheless be confident that coercion plays a significant role in American-style plea bargaining. And second, I will argue that coercion-fueled mass plea bargaining is analogous to an aggressive stage 4 cancer and calls for correspondingly strong medicine in terms of policy responses, of which I will offer 4 specific examples. Turning to the proposition that coercion is pervasive in American-style plea bargaining, I'll begin with a metaphor. Some of you may be familiar with the concept of dark matter in astronomy. Simply put, dark matter is a hypothesized substance that does not emit, absorb, or radiate or reflect light, and is therefore nearly impossible to detect, although its existence can be inferred from its gravitational effects on celestial bodies, including entire galaxies. This strikes me as a useful analogy for coercion in America's system of mass plea bargaining. As noted, coercion is virtually impossible to detect in particular cases, but its presence in the system may be strongly inferred, and I would even say demonstrated, by a number of observable phenomena, 3 of which I will describe here. We'll start with what we call the innocence problem. The first and most powerful evidence of coercion in the plea process is the fact that, as Professor Turner noted, innocent people are regularly induced to plead guilty to crimes they did not commit. There is an extensive literature on this point that has not been meaningfully challenged, which means the only real disagreement about false guilty pleas is how often they happen. There is an NGO in New York that some of you may be familiar with called the Innocence Project that uses DNA and other scientific evidence to exonerate people who have been falsely convicted. And while DNA exoneration is not infallible, it is the closest thing we have to certitude in this area. Of the Innocence Project's more than 300 exonerations, between 15 and 20% were false guilty pleas. The same holds true for the more than 3,000 people listed on the National Registry of Exonerations. About 15 to 20% of those were false guilty pleas as well. And given the difficulty of challenging post-conviction or getting post-conviction relief from a guilty plea, we can confidently infer that that's just the tip of the iceberg. And although it is possible to hypothesize reasons why an innocent person might plead guilty to a crime they did not commit without being coerced, for example, to save a loved one who actually committed the crime from being punished, applying the principle of Occam's razor, the simplest and most plausible explanation in the vast majority of exonerations is that the false guilty plea was the product of coercion. Further support for this proposition may be found in the writings of U.S. District Court Judge Jed Rakoff, whose 2014 article in the New York Review titled "Why Innocent People Plead Guilty" provides a harrowing first-hand explanation of the dynamics that produce false guilty pleas. Finally, empirical work by American law professors Lucian Dervin and Vanessa Edkins has shown that a key assumption in the U.S. Supreme Court's initial embrace of plea bargaining, namely that it is virtually impossible to induce an innocent person to confess to misconduct that they did not, in fact, commit, is, as Professor Johnson noted just now, palpably false. Further empirical support for the presence of coercion is found in historic rates of plea bargaining, which in America have exceeded 90% for decades. As previously noted, in the federal system, where we have the most precise data, 98.3% of all criminal convictions are obtained from guilty pleas. Plea rates in the states appear to be similar. These astronomically high plea rates are all the more suspicious in a system that provides criminal defendants with the extraordinary protections and advantages that we do, at least on paper, in America. These protections include government-funded defense counsel, the presumption of innocence, the requirements of proof beyond a reasonable doubt, and jury unanimity, pretrial disclosure by the prosecution of evidence favorable to the defense, the fact that acquittals may not be appealed, and the protection against successive prosecutions for the same offense. Given these and other advantages, the decision to exchange the possibility of acquittal and freedom for the certainty of conviction and punishment is simply not a rational one for most defendants, absent substantial external pressure. So let's turn to some of the mechanisms available to prosecutors to induce a guilty plea. American prosecutors have a variety of tools with which to exert plea leverage, and these levers appear to operate synergistically, so that the effect of their combined application may result in a greater quantum of pressure than if each were applied and measured individually. Moreover, because prosecutors tend to have no idea, and indeed probably have never even thought about, when the amount of pressure imposed by these levers crosses the line from permissibly motivating to impermissibly coercive, there is no reason to believe that prosecutors will exercise restraint in the application of these levers. On the contrary, in an environment where 90% or more of defendants end up pleading guilty, and where the failure to elicit a guilty plea can thus be seen as a professional failure on the part of the prosecutor, there is every reason to believe that these levers will be applied maximally until a plea is induced or there is literally no additional quantum of pressure that can be brought to bear on a given defendant. As Professor Ortman and Turner noted, the primary mechanism for exerting plea leverage in America is the so-called trial penalty, by which we mean the differential between the sentence offered to the defendant if he pleads guilty and the sentence that will be imposed if he goes to trial and loses. In some countries, such as England, The differential is capped by law. In England, for example, the cap is 30%, meaning that the maximum benefit a defendant can receive by pleading guilty is about a 1/3 reduction in sentence. In the United States, by contrast, there is no cap on the size of the differential, and massive disparities are perfectly routine. To take just one example, defendants in a high-profile college admissions scandal 6 years ago, many of whom were Hollywood celebrities along with wealthy bankers and lawyers, were consistently offered sentences of a month or two if they agreed to plead guilty, while being threatened with an additional charge of conspiracy to commit fraud, for which the maximum sentence is 20 years. Even assuming a guideline sentence of 4 or 5 years, that is a very long time to be away from your college-age children, as the prosecutors making those offers surely understood. Another way prosecutors can apply plea leverage is by increasing the defendant's sentencing exposure through strategic charging decisions. Generically referred to as charge stacking, this can include threatening to add charges that carry a mandatory minimum sentence, adding charges for which the sentence is required to run consecutively rather than concurrently, and shotgun-style charging, where a single act is characterized as violating a variety of different statutes, thereby increasing sentencing exposure and the chances of a so-called compromise verdict by a jury that figures where there's smoke, there must be at least some fire. So, for example, when computer genius Aaron Swartz was prosecuted for mass downloading restricted articles from the JSTOR academic database in Boston in 2012, federal prosecutors charged him with 13 different variations of computer crimes that together exposed him to 35 years in prison and a $1 million fine. He was offered 6 months if he agreed to plead guilty to felony charges. Sadly, Mr. Swartz took his own life during plea negotiations. Another effective tool for inducing guilty pleas is pretrial detention. That is, locking up presumptively innocent people while awaiting trial. The combination of isolation, anxiety, discomfort, and stress from incarceration and having one's life outside of jail start to unravel as bills go unpaid and employers, family members, and others lose patience, turns out to be an extremely effective tool for inducing trial waivers. Empirical evidence shows that people who are detained pre-trial are not only more likely to plead guilty, they do so more quickly than people who are not detained and are thus able to go on living their lives while awaiting their trials. Finally, for today's purposes at least, I'll discuss 2 plea practices that exemplify a category I call shadow levers. These are informal mechanisms, the use of which is not widely acknowledged and may even be denied, albeit not credibly, by prosecutors. The first is exerting plea leverage by threatening to indict or promising to drop charges against a defendant's loved ones when prosecutors have probable cause to believe they may have committed a crime, but no independent law enforcement interest in prosecuting that person. In other words, were it not for the opportunity to exert plea leverage against the primary defendant, prosecutors would not have bothered charging whatever crimes they contend the family member committed. This practice is not documented, and prosecutors typically only employ it in those exceptional cases where other levers have proven insufficient to induce a guilty plea. But it happens often enough that nearly all U.S. federal courts of appeals have had occasion to consider and unanimously approve the practice of threatening family members to exert plea leverage. The second shadow lever is referred to by some as diesel therapy. That's diesel as in diesel gasoline on which prison buses operate. This entails arbitrarily moving a defendant around from one custodial facility to another, often in the pre-dawn hours and with scant notice, in a deliberate effort to keep them exhausted, enervated, disoriented, and cut off from sources of support, such as family members and even their own defense counsel. Again, the use of this technique is entirely informal, but is nevertheless, according to those who have experienced it, highly effective. Now, we'll talk about proposed solutions. If the problems with mass plea bargaining are as dire as I and my fellow panelists believe they are, then it is a matter of utmost urgency to do something about it. Unfortunately, several dynamics combine to make plea bargaining reform exceptionally difficult. I'll not try to enumerate all of those dynamics here, but two that I think merit particular consideration are, first, the disproportionate number of former prosecutors among U.S. judges, and second, the extraordinary efficiency of plea bargaining, which has led policymakers to set budgets for prosecutors' office that reflect an assumption that nearly all defendants can be, and indeed will be, induced to waive their right to an expensive and time-consuming trial. Thus, it is widely acknowledged that without plea bargaining, prosecutors could only afford to try a fraction of the total number of cases they pursue, and one can well imagine the pressure they feel to induce guilty pleas, knowing that the only alternative, given budgetary and resource constraints, would be to pursue far fewer cases if the majority of the cases that they do bring had to be tried to a jury. As to the disproportionate number of former prosecutors on the bench, this presents an obvious challenge for plea bargaining reform because so many sitting judges themselves engaged in the very plea practices described by me and my fellow panelists, making it highly unlikely that they would ever find anything wrong, let alone unconstitutional, with those practices given their own complicity. Accordingly, I believe it is particularly important to consider reforms that, one, do not represent a direct challenge to the legitimacy of plea bargaining, and two, can be imposed upon the system against its will and without the support of judges, prosecutors, or other system actors who, by virtue of their own participation in mass plea bargaining, can scarcely be expected to see anything seriously wrong with it. Here are 4 ideas for ameliorating the pathology of coercion-fueled, plea-driven mass adjudication. An intriguing and I believe quite practical reform proposal, credit for which goes to Professor Kyle Brennan Marquez at the University of Connecticut, is to audit the plea process with a so-called trial lottery, the mechanics of which are straightforward. You take a random sample of cases in which a plea agreement has been reached but not yet entered, and you send those cases to trial to see whether the government can carry its burden and convince a jury to convict. If so, the defendant receives whatever agreed upon plea deal there was. After all, it wasn't his decision to take the case to trial. But if not, the defendant is acquitted, then of course he goes free. And if the jury cannot reach a verdict, so if we have a hung jury and a mistrial, the prosecution may choose whether to retry or dismiss the case. One particular virtue of this reform is that it would settle once and for all a burning question about which reasonable people can and do disagree. And that is whether a defendant's decision to plead guilty represents an essentially infallible proof that he is in fact guilty, as apparently most judges and prosecutors believe, or whether instead plea bargaining enables prosecutors to obtain convictions in a substantial number of cases in which they would not have been able to secure a unanimous guilty verdict from a jury, which is my supposition. In any event, it would be exceptionally valuable information to have, and if we wanted to, we could easily obtain it by implementing a trial lottery. Next is sentinel event review. In other areas involving complex systems and high stakes, commercial aviation, for example, and medicine, it is routine to perform a sentinel event review in the wake of a serious failure, such as a plane crash or a doctor-caused fatality. The point of these reviews is to understand what caused the failure and remedy that problem in order to prevent future bad outcomes through the same causal mechanism. However, despite the prevalence and demonstrated utility of sentinel event review in other settings, I am unaware of any jurisdiction in America that routinely, or really ever, perform such a review in the wake of an exoneration. That is both deeply irresponsible and quite telling. Perhaps those responsible just don't want to know. The third idea I call plea assessment panels. As discussed, one of the biggest challenges with coercive plea bargaining is the inability to demonstrate its existence in any particular case. There are several reasons for this, including the inherent Socrates paradox, or problem of the heap, which manifests in this context with the fact that it is impossible to say precisely where the threatened trial penalty crosses the line from non-coercive, let's say offering a one-day discount, plea discount for a 10-year sentence, to plainly coercive, which I would say offering people 1 or 2 months in prison and then threatening them with 20 years, as in that college admission scandal that I mentioned. And of course, another problem is subjectivity, in that we all have different tolerances for different kinds of pain and punishments. One possible response is to impanel a group of ordinary citizens and share with them the terms of any proposed plea and ask them whether they would or would not be strongly tempted to take the proposed deal, even if they were innocent, in order to avoid the threatened trial penalty. If a supermajority of the panel says yes, then the plea would be certified as presumptively coercive, which would trigger a right on the defendant's part to take the case to trial, with the lighter punishment of the plea offer serving as a cap on a potential sentence if they're convicted. Among other things, this should give prosecutors an incentive to self-police in terms of threatening grossly disproportionate trial penalties, because the more pressure they seek to exert with that lever, and the greater the differential between the sentence offered and the sentence threatened, the more likely they are to trigger the right to a trial with a capped sentence, which is the best of all worlds for the defendant and a suitable penalty for the prosecution for making a clearly coercive plea offer. Finally, a promising reform that could be imposed on the system against its will entails informing prospective jurors about their full range of powers and prerogatives in the U.S. justice system, including the power to acquit against the evidence, sometimes referred to as jury nullification. Despite a general consensus among U.S. scholars and judges that criminal jurors do in fact possess the power of jury nullification, which I believe is more accurately and less pejoratively called conscientious acquittal, we not only fail to advise jurors of that fact, we allow judges to exclude from jury service anyone who expresses an openness to, or even just an understanding of so-called jury nullification. Not only that, but judges and other system actors deliberately seek to instill in the minds of prospective jurors the inaccurate belief that their only legitimate role in the adjudicative process is to assess the evidence presented at trial and then robotically apply the law as given to them by the judge to whatever facts they have found to mechanically produce a verdict. That is not an accurate account of the true role of jurors in the American system, but it is the mindset that judges and prosecutors prefer and therefore seek to inculcate. The idea with jury independence would be to present a counter-narrative in the form of a public education campaign that would seek to saturate a given jurisdiction to the point where it becomes impossible to impanel a jury that is free of people who've been exposed to the campaign, and along with it, a correct, or at least competing, account of the true role of criminal jurors in the adjudicative process. I'll close with a practical suggestion that I respectfully make to anyone in the room representing a defendant in any U.S. extradition proceeding. In the presence of the magistrate who will decide whether to grant the extradition request, ask the prosecutors from the U.S. Justice Department if they can assure the court that the defendant will not be subjected to coercive pressure to plead guilty, including specifically the threat of a massive trial penalty, creative charge stacking to maximize sentencing exposure, threats to indict family or friends in order to exert plea leverage, and being shuffled around from one pretrial detention facility to another in the federal prison transit system as a prelude to an all but inevitable plea discussion. You may not get an honest answer, but then again, You might not need one. When it comes to coercion in American-style plea bargaining, we can confidently say, res ipsa loquitur. The thing speaks for itself. Thank you.
Okay, thank you very much, Mr. Neily. I believe that, thank you very much. Now I don't have to shout quite as loudly. We have about 12 questions and a little more than 45 minutes. So I'm going to start with some oral questions from the floor, and I think we can do this. I'm gonna ask that we all keep our remarks on the briefer side so that, oh, thank you, so that everyone who stuck around has a chance to ask their question and actually have it answered. I also need to apologize in advance for the terrible job that I'm going to do pronouncing everyone's names. My apologies. Okay, so the first person to have a question from the floor, Edgar Aguilera. If you could please stand, then they can bring you the microphone. Oh, thank you.
Thank you so much for such a amazing and eye-opener presentation. So my comment is the following. I was, from an outsider's perspective, I think that it seems to me that to say that the pervasiveness of plea bargain mechanisms is a departure from the adversarial ideal or model is kind of an understatement. I think it is also and mainly a departure from the accusatorial ideal. By that I mean the proof structure that we have historically come up with in order to trying to decrease or to lower the risk of false convictions. By that I mean the presumption of innocence, the burden of proof on the shoulders of the accusation, and also a very high or very exacting standard of proof. And we have seemed to, or in the US and elsewhere, seem to replace that with these practices which ultimately depend on a very low standard of proof, which to me it seems, and you can correct me if I am wrong, to be the probable cause standard of proof, which being the case that it is lower than the preponderance of the evidence, the political message that we seem to be sending if plea bargain mechanisms become so pervasive is not only that we are indifferent to the costs of false convictions and false acquittals, but the more serious message to me is that false acquittals or false negatives are more serious mistakes than false convictions. And I don't know if you agree with that kind of portraying the subject. Thank you.
Sorry, there was false. The question is about false acquittals, the concern about false acquittals versus false convictions, right? I mean, I think that's partly what I meant in that this might not be good for defendants. Now, obviously, if you're pleading guilty, you're not being acquitted, but you do have we've been talking a lot here about the issue of coercion of defendants to plead guilty, but on the flip side, Professor Turner had a post with Jeffrey Epstein on it. Jeffrey Epstein represents the opposite issue with plea bargaining, but still very much, I shouldn't say the opposite issue, it's part of the issue, right? It's just, you might say that the people who are hurt are different, right? Epstein ended up getting an amazing deal, right? There were multiple, for those who are not familiar, right, multiple women or girls who had claimed that he had sexually assaulted them, and he, I think, pled guilty to 1 count of prostitution and got a great deal. That's not an acquittal, but it was essentially an acquittal on all the other charges of rape for which he should have been charged. So, I think what's interesting is in the US system, there's a real fear, and I'm sure this happens in other places too, of people being falsely acquitted, right? The innocent walking out the door after a trial because the, proof beyond a reasonable doubt is such a high standard, and that worries people. And, what I always say is that, of course, it happens, but it really doesn't happen that much. The thing that happens much more frequently is that really guilty people who have done terrible things are able to negotiate a deal for one reason or another, because the plea system is endlessly flexible and provides for all sorts of ways to maneuver around the consequences that we've set up in the system. So I think, if you're concerned about defendants being coerced who are innocent or who are not as guilty as, the plea may indicate, I always say you should also be concerned about victims who are, being harmed by the fact that our plea system allows for bad actors to escape accountability.
The next question goes to, is it Vinicius Vasconcelos? You should say your name when you get the microphone so people know what your name actually is. My apologies.
So, thank you very much. My name is Vinicius from University of São Paulo in Brazil. As I understood, you always stated that plea bargaining in the United States is inherently coercive. In civil law systems, like in Brazil, many scholars tend to resist importing those criticisms, arguing that in Brazil or in those civil law jurisdictions, there are many differences from the US system. But we are walking really fast and persistent to those paths to the widespread adoption of criminal agreements. But what we observe now in Brazilian courts is quite similar to the reasoning that you have in the United States, like the idea that agreements voluntary by definition, that only guilty defendants would accept it, and that the mere presence of a lawyer guarantees that the agreement is legal. Or perhaps even worse, we are seeing case law in the high courts holding that there are no room for the judicial review of the agreement after the defendants accept it, and even saying that the oral hearing is not mandatory, even though the law does say that it's obligatory. So we are rapidly moving towards the generalization of these criminal agreements, but paradoxically, we are doing so already reducing the guarantees and the safeguards of the system. So I would question, was there a particular turning point in the United States that you say that then the system becomes coercive? How can we transplant it to other systems? And perhaps the $1 million question, what can be done to avoid the erosion of the judicial review in those scenarios? I would ask it to Professor Turner and to Professor Ortman, maybe, on the historical perspective. Thank you very much.
History, the turning point.
Sure. Thanks very much for the question and for that interesting perspective on the developments in your country. As far as a turning point where plea bargaining becomes coercive, I think that's hard to say for a number of reasons. One is that the coerciveness of plea bargaining, which in large part depends on the size of trial penalties, is along a continuum, right? And so, it's like boiling the frog in the pot. It happens at some point, and it's very hard to say exactly when, even if we had sort of perfect historical data. I think that the critical turning point for us, though, was when our Supreme Court accepted plea bargaining as the new normal, because it did it in such a way that in cases that have been talked about, Brady and Santabello and Bordenkircher, that the court made clear that it was not going to seek to regulate the sort of practices that prosecutors could engage in to put pressure, to put leverage on defendants. And engaging in that sort of review, some sort of requirement of proportionality between either the offense or the punishment, or between the original charges and the negotiated charges, is a really difficult project, right? Because it requires courts to look inside what's going on within prosecutorial decision making. But I think it's an important project, and I think our legal system missed the opportunity in the 70s to begin that project.
Thanks for your question, and it's a really important one. Is there any way to try to prevent the almost inevitable advent of coercion? I think if I could go back in time and add one single dynamic, it would be this. Think about what happens when you take a high-stakes, complex system like adjudicating criminal charges, and you strip away guardrails and safety mechanisms. Obviously, you increase certain risks, and I think one of those risks is clearly the risk of a false conviction. Think about who bears that risk in our system. Right now, mostly the defendant, to some extent the victim, and to a lesser extent unknown future victims. If there's a false conviction, we've got a perpetrator out there never brought to justice, and obviously that can lead to victimization as well. Imagine how different things would be if prosecutors and perhaps even judges could be made to share in the risk of a false guilty plea. So for example, if somebody pleads guilty, is later exonerated, those who participated in that false conviction paid some kind of a price. My prediction is that you would see the amount of plea bargaining go down substantially, but not to zero, because there probably is some number of cases where prosecutors and maybe even judges would be willing to take a fairly substantial risk because they are so certain of the defendant's guilt. And those are the only cases, in my view, where there should be a plea bargain. And I would say to prosecutors, if you're not certain enough to put some skin in the game, then you're not certain enough to make a plea offer.
So I know that Professor Turner and Professor Johnson have something to add, and then we'll move on to the next question.
Yeah, so thanks for sharing the experience of Brazil. It's very interesting to hear, albeit somewhat dispiriting. But as far as how to move forward to persuade whoever is responsible, policymakers and courts, of the need for greater judicial review, I think on the one hand, you can point to, of course, the, what we discussed, kind of innocent people who have pleaded guilty and the costs of that, as well as cases like the Jeffrey Epstein and other cases which have, imposed costs on victims. So you could point to those dynamics as sort of the costs of insufficient procedural safeguards. On the other hand, you also have to present, there are efficiency concerns, but you can present alternatives, right? So there are jurisdictions that have more scrupulous judicial review, and the sky hasn't fallen. And in fact, there are jurisdictions that have bench trials rather than simply relying on plea bargains, and the sky hasn't fallen. And I know Professor Weigand is here, but he and I and Professor Michele from Italy are writing about abbreviated proceedings. That's another mechanism that can be used instead of plea bargaining to think about a way to kind of find that balance between efficiency and fairness. So kind of pointing to those alternatives as well, that you can do them without, the system crumbling.
Professor Johnson?
Yes, just very quickly. I do want to say, as Professor Ortman said, there was no architect of U.S. plea bargaining. It sort of developed in the cauldron of, we actually have an adversarial system, but we're moving further away from it. And I think one of the benefits in Latin America, which has adopted plea bargaining largely, right? And in some places, I know in Chile and Colombia, more than 90% of cases or more than 80% of cases are being plea bargained. The one benefit is that you can have an architect, right? And you already do hear about experiments in Latin America where they do require certainty from the judge to establish a factual basis that is meaningful. And I think, I think plea bargaining is just a thing that's going to happen everywhere. And hopefully it's taking the lessons of the US getting it so wrong and then saying, if we're going to take this deeply problematic thing, let's do it in a way that we learn these bad lessons, yeah.
So following up on that question, we have a written question for Professor Johnson, which I think would allow you to elaborate on something that you just said. The question is, are there any mechanisms that have proven effective in limiting or rationalizing the use of plea bargaining? For instance, have sentence-based constraints, such as limiting the quantum of punishment to which plea bargaining may apply, been shown to have any impact? So you just mentioned certainty for judges. Are there other sort of limiting effects that you might recommend?
Yes. I mean, so my guess is Professor Turner knows more about this in many ways than I do in terms of like what experiments have been done and if whether they've been effective. But as I noted, I mean, there are lots of countries that are plea bargaining, but they're plea bargaining in ways where they're demanding some level of evidence or they're limiting the trial penalty. There's all sorts of ways in which you can end up with a plea bargaining system that produces more truthful outcomes. I think they're less efficient, and we have in the US sort of put efficiency as kind of the #1 goal, and, you know, query whether judges and lawyers, and I mean, one of the things that's interesting is if you go into a courtroom, and I think Professor Ortman was talking about this, everyone actually agrees, the defense attorney, the prosecutor, and the judge, for their own sort of self-preservation, they all want plea bargaining, and so they're not that interested in these experiments. And so then it's thinking, right, about how do you force them to engage in the experiments. But in terms of what experiments have actually had results, I don't know if there's certain methods that have produced more factually based results, but you can imagine that even having a judge say, I am required to take evidence before I accept this plea would give us more confidence that we have a plea based on reality.
Okay, let's take another oral question from the audience. I have Jordi Ferrer Beltran.
Well, thank you very much for this amazing panel. Thank you, Professor Carissa Hessick. Thank you for organizing this discussion and for having gifted us an amazing panel composition, an excellent one, if I may say so. The audience might not know this, but these cases discussed, in these cases, it is the coordinator of the panel who selected the speakers. The coordinator invited them, so thank you. Thank you very much to the 5 of you, especially to you, the coordinator. Now, having said that, I think that after this afternoon and evening, we should all be convinced in that this is a very bad system for criminal justice, and that it is something like the going back to pre-enlightenment, right? All of a sudden, we go back to the idea that confession is enough proof, is enough evidence in order to sentence someone, to convict someone. And I believe that, as some of you were saying in your presentations, the failure of evidence, right? In a conference about evidence, we are talking about a system that is leading us to conviction without evidence. And it is about this that I would like to ask you a question. In Ibero-American systems, in Latin American systems, Spanish-speaking systems, and also Portuguese-speaking systems, in approximately 11 of the 19 different systems that incorporated mechanisms of plea bargaining, or so-called plea bargaining, or in some other way, abbreviated procedure, conformity proceeding, so on and so forth. In all of these systems, in 11 of those 19, a judicial supervision or control is established. Law says that the judge, the court, the tribunal, must exert control on the sufficiency of evidence that the prosecutor has before reaching an agreement or validating an agreement. But in none of those 11 systems, the standard of proof is established for exerting that control. The practice is control or supervision is never done or exerted. So the only thing we need is the agreement. The agreement is, I wouldn't say proof enough or evidence enough, but let's just say it's enough to convict. And this leads me to say, if we wanted to put into practice what the law says, that is that courts should control sufficiency of evidence in addition to acceptance, that is setting aside the agreement, that they control the sufficiency of the evidence. The problem is what the standard of proof is, right? And at what point in the procedure would it be suitable to do that, whether it's at the beginning, in which case we won't have a lot of evidence, or whether it is further on, once the investigation has been concluded, whereupon we can ask from the prosecutor to a set of significantly powerful evidence. I believe that if this system is here to stay, and I am pessimistic in this regard, I believe it is here to stay, unfortunately, but in that case I believe that we should focus more on this path. We cannot accept an agreement unless it is after having defined adversarially that there is enough evidence in order to go to trial. Only after we know there is enough evidence to go to trial, and after then, and even probably I would say before the beginning of the trial, there can be an agreement, a settlement that would make the trial not necessary, but only then. And then the discussion is, what would be the standard of proof to make such a decision that more than likely should be more precise than the probable cause, right? So we would be close to something that would give us a certain degree of guarantee with sufficient evidence, judicially controlled and with an adversarial mechanism, after which the confession would be producing, let's say, the substitution of the trial via confession, but not the substitution of the evidence, which is the problem we have today. Nowadays, the mechanism is based on substitution or replacement of the evidence and not the trial. And this is what brings us to, or back to, pre-enlightenment. Thank you.
Let me say I think this is an excellent question, and I'm sure that my fellow panelists also have thoughts, but I wanted to just share a couple. First, in the non-United States common law countries that I have studied, they have standard discounts for people who plead guilty, and they are tied as a matter of law to how quickly the person pleads guilty. Because the systems have guilty pleas for efficiency. The longer the case is around, the less efficient it is. So the defendant is encouraged to plead guilty as early as practical, and the discount that they receive gets smaller the more time passes. As I'm sure you can imagine, suggested in your remarks, that is the antithesis of having a system that cares about the collection of evidence and seeking truth. The more you value efficiency, I would say almost as a matter of necessity, the less value you have to place on truth. As for the question about what is the amount of evidence, right? What is the substantive burden of proof that we ought to have? I think you're asking an excellent question, and I have to say I'm a bit embarrassed. I don't think that the American sort of academic system, like we're so busy just saying, please have some law here. We've never sort of gotten to the point where we're speaking about what that burden of proof ought to be, what level of evidence the court would have to have. My inclination is to agree with Professor Johnson, who suggested it ought not be proof beyond a reasonable doubt. Whether it has to be as high of preponderance of the evidence, perhaps even higher, I would think it's something like that. But I certainly don't think that probable cause is sufficient. But now that you've asked this question, I'm going to spend more time thinking about it. It's an excellent question.
Wonderful points. Thank you so much. I just want to very briefly note two fascinating articles on this topic. One is by John Langby, and I think most of us has probably read Torture and Plea Bargaining. If you haven't read that one, it's indispensable. The second one, the title unfortunately has left my mind either because of jet lag or overindulgence since I've been here in Girona, but it's and I can post it because I can see that's possible. It's a recent article in which the author argues quite persuasively that confessions, and by extension plea bargainings, are forbidden in Judaic law. And there's an extensive amount of rabbinical commentary that offers a number of different rationales, including that your body is not yours but God's, and you can't do with God's property, engage in an act that would result in the loss of life. And I'm not an expert in this area, but it appears that so powerful is the incentive towards plea bargaining that in Israel they do allow confessions in criminal proceedings, notwithstanding what seems to me some fairly powerful historical commentary and sort of theological conviction against it. So I highly commend the article. Again, I'll make it available, but that aligns, I think, very powerfully with the insights of the.
Our second written question is for Professor Ortman. Professor Ortman, in your presentation, you outlined several possible causes for the rise in plea bargaining and convictions in the United States, phenomena that are often regarded as at odds with the pursuit of truth. So you say, the person asks, could one contributing factor be the increased efficiency or the widespread belief in the community that the investigative processes have become more effective or have a higher success rate? Because if the investigations are perceived as more successful, might that not provide sort of a stronger incentive for this sort of system?
Yes, absolutely. Is my microphone? There we go. So I mentioned a couple of the more prominent hypotheses about why plea bargaining emerged when it did in the 19th century. Another one that I didn't mention is sometimes called the professionalization hypothesis, right? So the idea is that in the United States, professionalized police forces and professionalized prosecutorial offices are inventions also of the second half of the 19th century. And so the theory is that people at the time saw that there was a lot more investment at the investigation stage. And with more investment at the investigation stage, perhaps there could be less investment at the adjudication stage or no investment at the adjudication stage. I think that leaves a lot of unanswered questions. It requires us to put a whole lot of faith and trust into people who are into a realm of our government that is not meant to be neutral and leaves out any meaningful check for the part that is supposed to be neutral. But absolutely, I think that could have explanatory value.
Great. Our next oral question. So our next oral question comes from Jason Chin. You can identify yourself. I know we've lost some people. Jason Chin. Great. Thank you.
I asked two on there. I'm not sure which one you want me to do. I guess
It's your choice.
you were talking about coercion, and I thought that was interesting because I think there's maybe, this is more of a thought question, but as trials become less and less diagnostic, and as the penalty gets higher and higher, is there an argument that the rational decision is just to plead out at that stage? Maybe that's an assumption of what you were saying, but that was just my off-the-cuff thought.
So definitely you can actually sort of do a mathematical equation here. You could calculate your expected punishment, right? Your chances of conviction times the expected sentence. So if you have a 50% chance of conviction and you would be, receiving 5 years in jail if convicted, if they offer you anything less than 2.5 years, it would be irrational to say no. So I don't know that defendants always have access to the information that would allow them to calculate precisely what their odds are of conviction. And depending on which U.S. state you're in, you wouldn't necessarily have access to a precise sentence that you would receive upon conviction. But I certainly agree with you that it would be irrational to try to go to trial. And I think that was really illustrated by the cases that Clark was talking about, right? The federal sentencing guidelines said you would get 4 or 5 years in prison, and people were being offered a month. You would essentially have to take that unless you thought there was essentially no chance of conviction at trial.
I would just add one thing. When you get to know somebody who has been falsely coerced into pleading guilty well enough to be absolutely confident that it happened, you will never forget their story, and you will never doubt that it happens in our system. It is so raw and so vivid, and they will never forget it. It is, at least the people I've met, the most significant thing that ever happened to them, and it is an outrage. And if you detected a certain amount of emotion in my presentation, I feel like to some extent I was speaking on behalf of those people.
We have another oral question. This is Pedro Luis de Almeida Camargo. I'm sorry. Thank you very much for identifying yourself, despite my pronunciation.
Hi. I just have a very quick question to Professor Neily. You talked about the various tools that prosecutors use to have leverage in plea negotiations, right? I was wondering if prosecutors can and do use, for example, illegally obtained evidence or evidence that would be otherwise inadmissible in trial as leverage in those negotiations? And if so, what can be done specifically about this? Thank you.
I appreciate the question. I'm going to defer to my fellow panelists who have more experience of this. What I have seen more, and maybe we can comment on which seems more prominent, is the withholding of materially favorable evidence that would be they would be required to produce to the defense if the case went to trial. So in other words, a prosecutor may be sitting on evidence that they know would either be helpful to the defense or may even exonerate the defendant, and we still have examples of cases where they have induced a guilty plea without producing that evidence. Now, I know that's a somewhat separate question from the one you asked, but I think that's, for me, a more familiar dynamic. I couldn't name a case I'm aware of where a prosecutor tried to exert plea leverage by essentially trying to advance evidence that would likely have been excluded at trial. Perhaps others have heard of that, but I absolutely wouldn't rule it out. So I think you could count that as another probable lever. And I guess the last thing I'll say is I have certainly encountered criminal defense attorneys who have practiced in jurisdictions where they are explicitly told by the prosecution, if you make any significant effort to mount a defense, including filing a motion to suppress the admissibility of unlawfully seized evidence, there will be no plea offer and we will take this case to trial and get your client the maximum punishment. So that's a variation on that theme, I would say, and I think that's an extraordinarily discreditable and arguably illegal practice, but it appears to be somewhat widespread.
I'll just note it is widespread because when I was practicing 15 years ago in New York City as a defense attorney, and marijuana was illegal and it was a very frequent arrest, and it was absolutely known that police would go up to young men, often young men of color, search their pockets, find marijuana, and you'd say to the prosecutor, you know, that officer had no reasonable suspicion to stop my client. There was no reason at all to even have an encounter with my client. The prosecutor would say, well, you could try to go and do a suppression motion, but if you do, my really good offer today is, 3 days in jail, and my offer after the suppression motion will be the full 1 year that's available on the misdemeanor marijuana possession. So you can give that a shot if you'd like, but as I think it was Clark noted, if you're sitting in jail, you're not going to do that. You're going to take the 3 days, even though everybody knows, everybody, including the prosecutor, including the police, that the police perform that search illegally. But your chances of getting to the suppression hearing where you will litigate the illegal search is really, it's vanishingly small.
So another oral question before we switch back to some written questions. Tiago Turbe Freire, does that sound like it might be someone's name? Yes, thank you very much.
Hola, buenas, creo que la pregunta...
Well, my question has to do with what George said. And I just wanted to make some remarks about that. So, what you said about a previous proceeding, a preliminary proceeding to the hearing, I'm not really certain this is a good solution. So, I believe that the effects of reaching a bargain and agreement are different from a conviction, of course, but it's not the same as starting a hearing, a judicial proceeding, because there's even financial impacts. If the goal is the efficiency of the bargain, of the negotiation, of course, there's going to be more serious effects in having a judicial hearing besides the higher chances of a conviction. So with this remark, there's two further remarks I would like to make. I believe it's clear there should be a preliminary evidence gathering proceeding before the bargaining, before the negotiating, because reaching a bargaining with no previous proceeding is authoritarian in all regards. So if we agree on that, the degree of evidence sufficiency, we need to find the strategies to improve the quality of the judicial system. So the standard of the proof should be higher, even if it's to reach a bargain. So this is just the remarks I was thinking of on what Professor said. Thank you so much.
We appreciate those remarks. Thank you very much. The next written question is for Clerk Neily. What role should the judiciary play in setting both substantive and procedural boundaries for plea bargaining? More specifically, how far should judicial oversight extend, particularly with regard to the assessment of the factual foundations underlying negotiated guilty pleas? And then a follow-up question, sort of given the significant variation across legal traditions, including civil law systems, how can courts strike a balance between procedural efficiency and the protection of fundamental rights?
Thanks so much. I'll tackle the part of the first question first. I think some of my fellow panelists are probably better suited to answer at least part of the question. I'm deeply skeptical whether it's possible to craft a judicially administrable standard on coercion. I'm just not convinced that judges would be able to identify the line that I referred to in my talk between a permissible inducement and an impermissibly coercive offer. So I tend to come at the problem differently. As you may recall, I like the idea of involving ordinary citizens to assess a plea and just sort of get a gut feeling from them. One of the issues about judges, of course, is that they work in the system. They become inured to it. Even the ones who weren't prosecutors before, just get really used to the idea that most cases should result in a plea. And even as I think Professor Ortman suggested, that there's something, rebellious or discreditable about a defendant who refuses to plead guilty, and they deserve some additional punishment for doing that. So I think there's some merit to the idea of conducting at least some judicial oversight of the plea process. I really like the idea of requiring production of at least some evidence. I think that would be a significant step in the right direction. And I think reasonable people can disagree about how useful it would be to involve a judge or some other magistrate in, essentially trying to assess the nature or the substance of a given plea offer to see if it crosses some line. Personally, as I said, I'm skeptical of their ability to do that in any meaningful way, but I also hope that I have the humility to say I could be mistaken about that, and again, others may feel differently.
Professor Turner?
Sure. So I'll add a couple points. One is in terms of coercive plea discounts. I mean, there are systems that have tried to regulate that to some degree. So Italy sets a maximum plea discount. We talked about, I think Clark talked about. England does as well. Now, the problem in England is that you have charge bargaining. So, in the US system, that's the problem, that even if you set a plea discount, unless you also regulate charge bargaining, you still can end up with coercive practices. In Italy, you don't have charge bargaining, so it's much more effective. You also have the experience of the German Constitutional Court, which applies sort of a proportionality analysis to try to figure out whether the sentence, even after a plea bargain, is still proportionate to the defendant's guilt, and has, the appellate courts in Germany have struck down some sentences as disproportionate. And where you could look to those experiences to kind of say, well, maybe anything over a third is likely to be coercive. Maybe you kind of, the higher you go above a third, the more suspicious or suspect it gets. But then you have issues with What about the situation where you have, any possibility of a prison sentence if you go to trial versus probation or suspended sentence if you plead guilty? That's not a percentage discount, but it can make a huge difference whether you go to prison at all or you get probation. That's potentially quite coercive. So it can't all be regulated with a percentage. So I think the proportionality analysis might be a better one. And as for judges getting involved, I think Professor Johnson already talked about that. I think she and I are in agreement that judges can do more. And this goes back to the question of what's the standard of proof and so on, but they can do more to require the evidence to be produced at these plea hearings and ask questions and so on. So, and again, we have experience with that at some systems. And of course, again, inquisitorial systems have the file, so you have that as a possibility to check against the answers that you're getting at the plea hearing. So certainly more can be done, but I understand that in practice it often doesn't happen. So that's the real issue. You could have the rules. Even in the US, we have the factual basis requirement, and different courts have interpreted it differently. What exactly does it mean? But then in practice, in the same jurisdiction, you have some judges who are engaging in very detailed factual basis inquiry, and then you have other judges who are speeding through the process. So, a lot of that is also can't be fully regulated, but greater appellate oversight would also be useful. But the problem we have in the U.S. is that appeals are waived as part of the plea agreement. So that's another thing that's a potential problem, right? That it's hard to regulate it if you don't have an appeals process.
The next oral question is from William Thompson. William Thompson? Wonderful.
I'm pleased you got to me. What an excellent panel. I live in a county, Orange County, California, where our local district attorney has added a new twist to the plea bargaining process in misdemeanor cases, requiring virtually everybody who's charged with a misdemeanor to give a DNA sample for a localized DNA database before having charges dismissed or accepting any plea bargain offer. This has resulted in over 200,000 people being in the database. It's now larger. Our local county database is now larger than the DNA databases of half of the U.S. States. And this is operated based upon the DA's theories that this may deter and help solve crime, although there's relatively little evidence that it does so. So I am the named plaintiff in a civil rights lawsuit that's been filed by the UC Irvine Legal Clinic, by the law firm of O'Melveny and Myers, and by the ACLU, challenging this database under a California statute that allows taxpayers to challenge misuse of governmental funds. And our argument is that anything that's illegal by the district attorney is a misuse of governmental funds. And so we're in the discovery phase of this lawsuit. And we're finding out a lot about coercion. For example, just deputy district attorneys are instructed as part of their training not to accept any plea bargaining that it doesn't include DNA, the voluntary contribution of DNA. Although, and we have lots of reports of charge stacking in cases where people say, no, I don't want to give a DNA sample, I just want to plead guilty. No, that's not allowed. Okay, and so this raises the prospect of plea bargaining being used. What troubles me about it, partly it's coercive, partly the disclosures that are provided to people before they provide their DNA are inadequate as far as what risks they face and what it will be used for. And there are all of those issues. But the thing I think that's most troubling to me about it and looking at it closely is that the decisions about what pleas to offer people are not being based upon any effort to achieve individualized justice for these people based on making the punishment fit the crime. So rather than the DA deciding to make a particular offer because that's what the person deserves, the offers are being made or not made based upon achieving another goal, which is to populate the database with DNA for the purpose of solving future crimes or perhaps deterring future crimes. And so decisions are being made about people's lives, not based upon what they deserve based upon the crime they may have committed, but based upon other goals that the district attorney has chosen to operate. So this raises, so I guess my question is, I'd love to talk to any of you personally about this if you have any comments or suggestions for the lawsuit, but is this a new twist on this? What do you think of this?
Well, as a former public interest litigator, I have two words for you: unconstitutional conditions. That's a theory I would advance if I were litigating this case. Sounds like maybe you have. For those who don't know, just very quickly, there is a doctrine in U.S. constitutional law that restricts the government's ability to essentially impose on somebody a condition that is not sufficiently related to whatever the waiver is. So for example, if you want to live in public housing, they're going to say, well, then you have to waive your Fourth Amendment rights against unreasonable search and seizure, and we can come in anytime we want without a warrant. That would be an unconstitutional condition on that benefit. And I would say something similar here. I mean, imagine they say, well, we'll give you a plea offer for your misdemeanor if you agree never to apply to a university in the state of California. Well, what the hell is the connection between that and the conduct at issue? And I would say you could make an argument, and hopefully it would be a strong one, that requiring a DNA sample as a condition of receiving a plea offer it operates as an unconstitutional condition, although I will say that judges wear blinders that are basically indistinguishable from a blindfold when it comes to the application of that doctrine in this setting.
Well, just a couple of things. So I agree with what Clark said, but also Professor Andrea Roth at Berkeley has written about this, so she would be a great person to consult, and she has written about the practice in California. But also, I guess another angle on this, and we don't need to get into the weeds, but even though the court has approved in Maryland versus King, has approved the collection of DNA of people who have been detained for serious felonies, and that has expanded since then. A lot of jurisdictions have expanded to misdemeanors. The justifications that were given for that are very different from what's happening here, right? Because it was for safety purposes and to identify the person. Well, none of that applies in the plea stage. So yes, we go back to the unconstitutional conditions question, which is very popular these days. There's a lot of unconstitutional conditions cases being litigated in the US right now. So we might get some good case law.
I'll just say to end on a bit of a pessimistic note, I'm very glad that you have the California statute that you get to work with here, because I don't think that American law about plea bargaining is going to help you very much. The Supreme Court and most of the state courts interpret plea bargaining as a negotiation, and they look to contracts, and they think it's inappropriate to limit the sort of free market basis through which people can negotiate. I mean, they allow all sorts of other things to be negotiated about, the criminal charges against family members, potential civil lawsuits against police officers who used excessive force and who violated people's constitutional rights. It's quite common in some jurisdictions to require defendants to waive any civil claims for money damages when there were obvious constitutional violations as part of a plea bargain. So I guess this is, again, one more piece of warning. It's not simply that plea bargaining is seen as efficient, but once we say this is just a matter between the parties to negotiate, then all sorts of things can get swept in, and it can be really troubling. I'm afraid I've given myself the last word, which I suppose is the moderator's prerogative. But let me thank you again for staying until the bitter ends, and thank my fellow panelists. We've really enjoyed the opportunity to speak with you. Thank you.